You gonna do the roll call, please?
Okay, roll call. Chair Virginia Sanders. Here. Vice Chair Katie Davis. Here. Member Beck Islop.
Present.
Member John Ryan.
Here.
Member Howard Warren. Absent. Town Manager Mark Cutney.
Here.
Town Clerk Susan Acorn is absent, and Assistant Denise Rodriguez. Town Coordinator. And Town Planning Consultant Jim Flashman.
Here.
Alright. Today is Thursday, May 16th, 2013, 5:30 PM. This is meeting of the Unified Land Development Code Review Committee. Call the meeting to order, and do we want to, we did the roll call, we called the meeting to order. Everyone is present except Howard. Go to that.
Did you say May 16th, that you got last month's?
I think
Oh,
she meant to say June 20th. She said May 16th, yeah.
well, perhaps, let me make sure I have the,
Those are the minutes that you have there.
oh, I thought I printed out page
Yeah.
1 of the agenda for.
The minutes are May 16th.
I apologize, let me correct that, Thursday, June 20th. I did a print, I apologize, wrong agenda, I printed it out. Thursday, June 20th, 2013, 5:30 PM. Okay. We need to approve the agenda.
Move to approve.
Give me 1 second. Second it. All in favor?
Aye.
Okay, everyone approved, no one, what would we say, 4-0, do we have to?
You don't need, now you don't need it.
All right, in the minutes, I want to review the minutes and approve the minutes.
Approve the minutes?
Excuse me, Dad?
And we love the minutes.
Well, we approve it, we're going to approve it and then review, correct? Remind me,
Well, no, if there's any questions on the minutes, I mean,
we review them first and then,
yeah, if you have any questions, fine. If not, we can
okay, yeah, if you want to.
need a motion and a second and approve.
Make a motion to approve.
My only comment on the minutes was that, and I appreciate the minutes.
Wait, time out, we don't have a second. She made a motion to approve, need a second.
I'll second for discussion.
Okay, very good.
That's
Thanks.
what I thought you was gonna, all right.
Yeah, minutes can be real brief, just recognizing motions and votes, or they can have a little discussion. I think that, I appreciate that we don't want long minutes, but I think that it is a good practice, and Denise puts the video on the website. I guess you'll get access to YouTube, and that's very helpful. But I think that, we just need to, if we have any questions from people that are reading the agenda packs, and, we just need to refer them to the videos to see the whole discussion.
Any other comments on these minutes?
Public comment?
We do public comment on it?
Is, okay, Keith has submitted a comment card for the minutes.
That's fine, I mean,
Okay.
it's normally a perfunctory item, but I guess if he wants to speak
Yeah,
about it, you
it's
probably should
unusual.
hold your vote until he has had a chance to.
Yes, my name's Keith Harris. I reside at 2580 C Road. Like clarification of the minutes of the last ULDC meeting. We had a lengthy discussion on commercial equine operations at the 2-hour and 38-minute mark of the tape. Board Member Ryan suggests that commercial equine operations be dropped from special exception use. All present members of the board at that time agreed. There's no mention whatsoever in your minutes that commercial equine operations other than that I made a lengthy presentation.
Okay, I do know, I also, just as a point, I believe you even mentioned it at town council that we had said, did you not bring that up at town council also? But
I
Jim-
brought up that there was a consensus kind of motion, but we were gonna, that's the reason why it's back on the agenda.
Okay, Jim? Jim has a comment.
Yeah, we discussed that when we were talking about the special exception. And there was a table that we went through in the agenda package last month that had a list of all of the uses that required special exception approval. And we had them categorized by category A, B, and C. And there were several changes that the committee would like to see to that table. One of which was to eliminate special exception approval for commercial equestrian operations. We also talked about changing mobile home back from special exception to a conditional use, and changing outdoor events from a special exception to conditional use. But we had some discussion on that, and there was sort of agreement on the part of the committee, but there was no formal motion.
Right.
That's why the board issued special exceptions back on the agenda tonight, so we can have formal motions recommending approval of the special exception and to that table if that's what the committee desires. So yes, we did have a discussion, and there was consensus about taking the commercial equestrian off that table, but there was no motion. So we're bringing it back to make sure that the motion is clear.
Did we not vote on that?
No.
And there may have been a discussion at the end where I may have said something about section 80, and we may have voted it. I think that was incorrect on our part, because as Jim said, we were talking about the table, and then I made a comment towards the end. It was a very long and lengthy meeting, and I think we need to correct, we're trying to correct that issue.
Yeah, we just want to have a formal motion.
Right.
That we can take back to the council, recommending hopefully approval of the special exception revisions to the ordinance, and also any changes to that table 2, which is out of the zoning districts. For clarity's sake, we'd like to have 2 motions done, one on the special exception section, and then also on that table that we have in there as well.
So 2 motions,
So, yes, we
special
did.
exception and,
And whether or not there are any recommended changes to certain uses in
on
terms
the
of what.
table, or,
yeah.
well, we'll get to it.
Yeah.
Any
yeah.
recommended changes, you'll let us know.
Yeah, it's in the agenda package
Right.
tonight, so we
Okay.
can talk about it.
Just as some further background, I gave the town, I think some of you were there, I gave the town council a report on your activities to date since since the origin of the committee. And you all have been very good about making motions, and I was covering all the previous 5 meetings and motions. As I got to the minutes, I realized there was no motion. We checked, Sue checked, and so I indicated that it was direction by consensus, but we'll go back to this meeting and we'll make sure that we have a motion so that it's.
I think that's a good idea.
Let me just ask you one thing, just as an interpretation. Since we've got the standard, you know, the town is 5-acre ag res, that's the standard. Commercial equestrian, that would apply to that, so that commercial equestrian would be on 5 acres, right?
You could do it that way. I mean, it's not an automatic. I mean, it depends. Sometimes there's different requirements for commercial, because generally they'll be in commercial zones. But in this case, where the ag is in the AR district, then unless you carve out a different number for the use in question, the presumption would be that it has to meet the minimum standards.
Yeah.
Well, let me ask the question, going off what you're saying. What is the minimum to be ag?
There's no minimum to the ag.
Then there's no reason to talk about 5
But
acres.
ag residential is a minimum of 5
Okay,
acres.
can we just get the minutes approved first?
Well, that's,
Okay, hold on, let's get the minutes approved. And we've noted your comment.
sorry.
No, that's okay. We took your public comment. Jim has.
I like starting dialogues. You know, what can I
No,
say?
Jim brought us up to speed, and we're gonna get the minutes approved, and then we can get into this discussion.
okay.
Okay, so Did we ask for approval of the minutes?
Yeah,
We
can
did.
we?
You have a motion and a
And John
second.
seconded.
For discussion
Okay.
by
Okay,
Mr. Ryan.
Okay,
All in favor?
Aye.
okay, 4-0, all in favor.
All right, can I ask my question?
Let's keep, we're gonna be on that topic, it's in the agendas,
Okay.
or is it not?
I don't think.
No,
it
that
is.
topic is not, and I can give John an answer real,
Okay,
Yeah.
let's keep, you want me to time you?
okay.
Go ahead.
I got my phone.
The minimum lot size in the AR district is 5 acres.
Right.
However, we have hundreds of acres, hundreds of lots in the town that are less than 5 acres. We have a provision in the code that says that if a lot is a legal non-conforming lot as of the time that the code was adopted in 2010, that any use in the AR district can be put on that property. So it is possible for a commercial equestrian operation to be located on a lot less than 5 acres if it was a legal non-conforming lot as of the time that the Uldc was adopted in 2010.
And then you would agree, I think, unless countermanded by provision which put in a minimum requirement for if we revise the use, I mean, it might be inconsistent with that we'd have to work that, but you can put standards on either making it a 5 acre or 10 acres or whatever, very much like we just had with the Big Dog Ranch.
Yeah, that's true. I mean, if we have if that use is specifically addressed in the conditional uses, and there's a specific lot size or set of criteria.
I think we generally agreed at the last meeting that it was a permitted use. I think that what I was trying to reconcile was for people that are coming in, that since we're 5 acres, I think it, should be for a 5 acre property. I mean,
It's a good point, so
The
what,
only
so,
problem with that
Oh,
is
go ahead.
on Casey Road and like Marcella, definitely, I know on Casey Road, there are some horse farms that are on 2.5 acres.
that they're
They're
pre-existing?
Pre-existing,
yeah.
so they would be
Yeah,
fine.
well,
So what happens if they sell?
Well, the way the code reads now, if it was a 2.5 acre, for example, lot, as of the time of incorporation,
Right.
or as of the time that the ULDC was adopted, it could do a commercial equestrian operation.
And that transfers when it's sold?
No.
No.
Well, I mean, that, as long as it was a legal non-conforming
That,
lot,
I understand that
then
part,
it can do anything under a
Right.
zoning district.
right. But John's question, where he's talking about 5 acres in general,
Well,
so
that's
that,
not what the code says now.
no, I know that, but the next question after that, since we're having this discussion, and it just, what happens, so you have the existing 2.5 acre equestrian property, and they sell that property under our code, then can they, the new owner cannot still be equestrian, can they, or can they? Yes, they can.
Yeah,
Okay.
it's the lot,
Okay,
it's not the owner.
okay, great, so that answers what you were asking, John?
Yeah, I guess that concerned me a little bit.
Yeah, I understand. I mean, I suppose that's something that could be looked at, but
But
that's
there's-
going to get really,
I mean, I didn't
They're
want
still under best management practices, and they still have to adhere to all the other, the water requirements that are coming up in the next few years. So
well, yeah, I mean,
they're
if it
still
wants
bound
to,
by all that.
if it wants to be bona fide ag,
Right.
yes.
Well, and if they're not bona fide ag, they still have to, it doesn't matter whether they're bona fide ag or not, they're gonna have to comply with the water regulations in the next few years,
Well,
right?
they'd have to comply with water
Right.
regulations, but the best management practices would be part probably of the bona fide ag.
Yeah.
I guess my only concern was we do have a lot of smaller properties,
Yeah.
and it'd be a significant difference in lifestyle if you lived on 1 acre on San Diego and somebody put in a barn behind that, or your neighbor next door. I mean, do you think that's a significant restriction on people that are new coming into the community
Well,
if they had to
if-
be on a minimum of 5 acres?
Well, here's the question, what if somebody comes in onto that acre, acre and a quarter, or 2 acres, whatever, and put in a couple of 4-stall barn, for example, and it's just what him and his wife, or him and his wife and his kids use. See, that's where it gets tricky on the whole commercial deal. I mean, if you put in a 20-stall barn and there's peak traffic coming in now, it keeps going back to the whole definition of agriculture. So if somebody lives on an acre and a half, or 2 acres, or 3 acres, or less than 5 acres, and they decide that they want to put 5 or 6-stall barn, that's their horses, are we gonna make it difficult for them to do that? I don't think we should, because it's their horses.
That would be private, that would probably be private.
But it goes back to that, if it's still ag, is it still commercial? And it goes back to what we discussed last time we were here a month ago. By definition, agriculture is commercial. We've gone through that a million
Well,
times.
if by
and I get
definition
five.
ag is commercial,
Yes,
then if it's commercial, it adopts best management practices if it's bona fide ag.
it is, exactly. So,
But just because it's commercial
but-
doesn't mean it's ag.
right,
Yes.
right, exactly.
So,
All ag is commercial, but not all commercial is ag.
All right, my concern in a recommendation, and, certainly, the majority vote is gonna be the majority vote, but I think that if it's a new owner who wants to change to having a commercial equestrian operation on smaller than 5 acres, that ought to be up to the town council to decide whether they want to do that change or not.
Well, let me ask you this, John. If the county does not zone them as a bona fide ag, then they can't be agricultural. Is that right? I don't
Say
know.
that again, if what?
If the county does not identify that property as bona fide ag, and Katie just said earlier that it needed to be 5 acres to be bona fide
it
ag.
can be an ag property, but not an agricultural exemption.
So if it doesn't have an agricultural, if the county does not give them an agricultural exemption, then they can't have an agricultural business on the property.
No,
Okay, it's
we
different.
did some checking in relation to a couple of requests that came in. In fact, Mr. Fleischman, to my left there, did that checking with the county. And the property, and I'll let him, but what they basically indicated is if somebody's coming in and trying to get a bona fide ag exemption, the problem is that the property appraiser can't, right off the bat, just because this person is telling you what they want to do, automatically make that assumption. There has to be a business plan or something, and maybe I'm stealing your thunder. Go ahead, you tell. You had the calls.
Well, that's okay, Mark, I mean, that's fine. But first of all, in our agricultural residential district, we have 2 uses. One is agriculture and one is bona fide agriculture. So our code
That's for the land.
is making a distinction between ag and bona fide ag. So I think that there can be an agricultural use that is not commercial.
So, example, I wanna cave into my family and finally put that barn up for the kids' horses on my property that I've been refusing to do, and I'm private, I'm not commercial. What is that, do I fall
Well,
under ag?
our whole discussion was commercial equestrian.
Yes.
Right, but
It
then,
was not,
right, but Pat did bring up a point, but Pat
I
did bring
I
up a point, and I just wanna make sure I understand both sides of the conversation. I understand the commercial side, so just to confirm what, the other side of it, so if someone has a piece of land and they're just putting up a small barn for horses for their own private use, they fall under regular ag, or what are they called?
Well, I would.
Or just private, just a private resident?
Palm Beach County Animal Control has different, a definition of private stables.
Okay.
And private stables is for the use of their personal horses, or they can rent out up to 4 stalls. And they still fall under the definition of private stable.
And we concur
Okay,
with
so-
that?
So I would think that that would be an example of something that falls under our definition of agriculture, not bona fide.
Right, that's what I just want to make sure I understood.
Okay, hold on, because we're going 2 different words, and we went through 5 months of definitions. What is agriculture and what is bona fide ag?
Bona fide ag is, only comes into play is if you get the exemption assigned by the property appraiser.
To the property.
It could be the exact same use.
To the property?
Yes.
Okay, and what is agriculture?
Agriculture is, there's a definition of uses that they're in Florida statutes.
That we went
qualified
through.
as agriculture.
And you can run an agricultural business
Huh?
on a property that's not bona fide.
Yeah, yeah.
We have to do.
Now, hold on, yes or no?
Yeah.
Oh, no, oh, you deferred it to him, yes or no? Can you run an agricultural business on a property that is not defined as bona fide ag?
Well, I would say yes.
Okay, yes.
Yes.
It would have to be
Okay.
zoned ag, but you.
Now, if a property is described as bona fide ag, if you're running a business on that bona fide agricultural land
Right.
that has to do with agriculture,
It has to be a business to be bona fide ag.
Yeah, bona fide ag presumes a
Bona
business.
fide ag. you
And it
have-
presumes you're
it has to
following
be
best
business.
management practices.
Agriculture itself,
yes and no, because some of the agricultural practices do not have BMPs.
Then they've got a problem.
Then they got a
No,
problem.
some of
Yeah,
them
they-
do not have registered BMPs.
That's their problem.
I understand, but does it say in the agricultural deal, you have to have a BMP? If there's no existing BMPs within the state, what are you
Then
supposed
they
to
can be
follow?
regulated. That's
By?
the issue. In the Right to Farm Act, if you have bona fide, if you have best management practices, then we can't, local government can't go and try to
Can't go.
supersede. But if there are no best management practices, we
Then
can
you can
regulate.
regulate, okay.
Yes, yes.
But
So that if the property is bona fide ag, and they're running an agricultural business, by definition, they're agriculture, they're stat, it's good.
yes, yes, but you can have an agricultural use and not be bona fide ag, is what I'm saying. One category encompasses the other, but the other doesn't encompass bona fide ag.
How do you prove the agricultural activity on a property that's not bona fide ag?
There's a list of uses in the Florida statutes that are agricultural uses. They don't necessarily have to be bona fide ag if they aren't a business.
And there's also-
Bona fide
If
ag-
they're not a business.
Bona fide ag has to file a tax
So I could
return.
put a beehive on my property, probably, or I could have goats in that, but I'm not in business, I'm not having to
Right.
file my tax return
Right.
or show my business plan. I would
But
just
but
be
then you would not get the
regular
ag exemption.
Right, and I wouldn't be, that's why I wanted to make sure that definite, I was just
But you
looking for
would be
clarification.
agriculture.
Right.
In addition,
yeah.
I believe this is the case, I have to double confirm it, but I believe Florida also, in association with what they do, they have used the Standard Industrial Classification Manual, which is not called that anymore, it's actually called the North American something something, but the federal government for years has put this out. You might have heard of the term SIC codes. Excuse me, they identify everything under ag. So, I mean, it's not like we're breaking new ground, this has been around for
So going back
years and years and years.
to the horse operations, if you have a horse operation, it's ag.
Yes.
It's ag, but not, my
It may
concern
not
was
be
this,
bona
we were
fide.
talking about commercial.
But that goes back to the
equestrian.
land.
Right, so your question specifically geared was
Right.
commercial question on smaller properties than 5 acres.
That's what I'm concerned
But yeah, we're
about.
not looking at the regular ag.
Yeah, if you're gonna take an ag res property where the town's standard, so to speak, is 5-acre property, and you just wanna use it for your private use, that's one thing. But if you wanna make a commercial equestrian use, then I think if you've got a small acreage and you've got neighbors with small acreage, and you wanna put a commercial equestrian operation on it, then I'm not so pleased with that.
Well,
Because that implies,
can we use that the same way in any other kind of commercial agricultural endeavor?
Well, this is a little bit different because there's an exemption involved by the property. I mean, you know, I'm not sure.
I'm just I'm asking John about that. Could you not, I mean, this is a double-edged sword.
Yeah.
If you say no horses, can you do no plants?
you know, I've got a problem with commercial agricultural uses on less than 5 acres, if that's
I
the
agree.
standard acreage in the town.
And anything that has not being so specific on one.
Okay, so
on
now
one.
we're talking
Oh,
about, now, I just want to be, for clarification, John, you said you didn't use the word commercial when you just said
Yes, he
that.
did.
Yeah.
He did commercial agricultural endeavor.
Commercial
Okay, I
agriculture.
want to make sure I heard that.
Yeah, I don't want to discriminate against anybody, but I do think, you know, if you had a 1-acre property and you wanted to put a nursery in your front yard, you were going to have traffic or something, I don't think that's right.
I don't need, or horses in that matter.
Yeah.
But if they're gonna have one or two horses, I don't think you have a
I
problem.
don't have a
with it.
problem with that. But,
Okay.
you know,
So how do we identify that? Now that we've come up with a,
Jim?
commercial agricultural instead of,
and do we specify an acreage number, or is there a state statute already
no, there's
specifying
no
something like
state
that?
statute that specifies, but we've got a standard 5 acres as part of our current
Which
plan.
is our local rule.
Okay.
Yeah. So can we tie commercial agriculture to the 5 acre minimum property size in our plan?
We probably, I would say you probably can, but you'd have to look at it, because, I mean, there are a number of factors, a number of uses that might, might require more than 5, or
Now,
That's a
I'm
no.
gonna really throw the wrench into the whole deal. This only has like 4.7 acres. I'm really stirring the pot here, but there are a couple of little deals because of the way stuff gets cut and the canals and all that.
Let's call that a special exception.
no, you'd call that actually a variance. If you
Variance.
really
Okay.
wanted to, you'd have to go get a variance.
Just like the town council
But
did
the
that
town would
variance.
pay for it.
Ooh, Herbie.
I mean, do you understand? I'm not trying to be,
Yeah.
I'm not trying to be obnoxious about it, but, I mean, there's some problems.
That's a variance.
Yeah, it's difficult because we have so many different lot sizes.
Yes,
And
it's not perfect. though.
it's hard for us to adopt a set of standards that's gonna be fair to everybody.
Okay, and
We have
here's,
to cut up.
okay,
Can
go ahead,
can I make
sorry.
one more point, Jane, as long as we're on this topic? At an earlier meeting, we were talking about when a property becomes bona fide. And I brought up the point that, well, if somebody comes in with a vacant piece of property and he's going to eventually have a bona fide business, at what point does he become bona fide? And Howard raised the point, and I confirmed it based on a conversation I had with the appraiser, that you could do a business plan and submit that to the property appraiser, and based on that business plan, you could get the bona fide designation.
Right.
But they have to act on it within a time, don't they?
But, yeah, on the next,
Within a year.
I'm not sure if it's by the next year or not, but anyway, there was a change of administration in the county appraiser's office in March. And I had a conversation last month with one of the agricultural appraisers, and he's told me flat out that they will not grant a bona fide ag designation based on a business plan.
Really, so they changed it?
Yes, you have to be up and running and show your tax return. So that leaves us with the dilemma of, we have a gap in between when a property is being developed for an agricultural use and the point that it has a tax return and it can go in and get the designation.
But
Yeah.
they could do that as either a maximum of 1 year, or they could do it at any time to be able to file January 1st.
Yeah, that's true. But my point is that, we can't impose land development regulations on bona fide ag. If somebody comes in with this, and I'm going to get into this at the end of the meeting, I have a very interesting example of whether or not we want to get into trying to regulate set controls on businesses before they get started. Or just say, you're going to be bona fide ag, do whatever you want. And this is one that,
I don't think we want to do anything different than the state statutes. The
Okay.
state statutes leaves it up to the property appraiser in the county to determine what's bona fide ag. So let's not get in the middle of taking over the property appraiser's role if the state statute says it's his role and not ours.
yes, no, I'm not saying that. What
I agree with what he's saying, but I'd really like to hear what you want to put at the end of the meeting, but it's going to be real interesting to say, okay, what happens if this person buys 10 acres and says, I'm going to put a 20 stall barn and I'm going to have
Yeah.
whatever?
This was
Now
a
what
request, we got a zoning confirmation request for a specific use.
Wait a minute, you want to take that out of order? We do have it on the agenda.
Yeah,
let's-
We're going.
And we've done 15 minutes on this topic,
Right,
and
it's gonna make-
let's get
it's gonna
back
make
on
my
the
point very
agenda.
clear, I think.
Okay?
My basic concern was commercial equestrian. Beck said we don't want to spell out any particular agricultural use. So commercial ag on less than the standard property size in the groves. That's my sense.
Right.
But I feel.
The only thing I wanted you to take away was we started that discussion kind of with the special exceptions, and that's why I said to you, yes, generally, probably, everybody would be meeting the 5-acre minimum in the AR district. However, if a certain use, if we're talking special exceptions, would determine that greater acres would be needed, then that's fair,
That's
and you can do
different.
that. And the example I cited was the Big Dog Ranch Rescue,
Yeah.
which is animal rescue,
Minimum,
which
yeah.
then the planning and zoning board, when they deliberated, they decided to make it a minimum of 10 acres, and that's an example, that's what I wanted to.
But it's not agriculture.
They're not trying to be agricultural.
Right.
There's an animal.
So
Right.
can, going on what you were saying, Virginia, can we do something to move on the special exemption, as long as it involves agriculture, to kind of close that chapter?
Well, we're gonna be going on this tonight, are we gonna have it tonight, a quick review here?
The special exceptions.
Yeah, okay, so let's move on then to the, Howard, welcome,
Don't stuck in traffic.
big city guy, are you?
You know, I reported to town council that you guys had perfect attendance, so you're keeping the record going.
That's right, okay, we are on item, so moving on to item 3A. Old business, ULDC Article 170, special exception uses, gentlemen.
Okay.
Madam Chair, here's where we're looking for the motion, and I'll vote basically just to memorialize the fact that we've already been recognized by council to go ahead and move forward on that project.
Okay, at the last meeting, we went over the changes to the language in the special exception that staff is proposing. If you go to page 10 of your agenda package, from pages 10 through 13. Now, we've incorporated those changes that we talked about at the last meeting within the ordinance itself. So we have all of Article 170, which is special exception uses, and we have the changes to the ordinance indicated by additions are underlined and deletions are struck through. So we also incorporated a couple of language changes that the committee recommended last time. They were fairly minor. There was one change on section 170-015, parens C. Let me see. See if I can find it here. Okay, yeah, now we added a site plan including a property and building layout with dimensions. That committee felt that seeing like a brief site plan would be very helpful, so we added that. And then section 170-040, parens A. We added the word and/or documentation that the underline there is something John recommended. So we've incorporated the two wording changes that the committee recommended last time, and on that basis, staff is recommending approval of proposed Article 170 special exception changes. And then also, over on pages 15 through 17, we have the advertising requirements that we had to revise somewhat because we created 3 categories of special exceptions, some of which have reduced advertising requirements over and above what they were previously. And those changes are on page 15. Where we talk about special exception A and C. we incorporated those changes, that there were no comments on the changes by the committee at the last meeting. So
Do you, I'm sorry, do you have a previous, do you have these not required, not required underlined? What were they previous?
well, it was only, if you go up to special exception A,
Mm-hmm.
okay, it previously just had special exception. And the
You
line.
split it up into three.
Yeah,
Okay.
where it says special exception A was the language that was in there.
Yes, sir, okay, I'm with you.
Okay, but we're still keeping, from what I'm seeing here, we're still, okay, go ahead. I'm sorry, oh, you're not finished yet, are you, or are you?
With that section, yes. So,
Okay.
so we're recommending approval of revisions to section 115-010 as proposed by staff. And the third item that we looked at last time, and this is getting into the issue of what uses should or should not be special exceptions. If you look at page 14 of the staff report, that has a list of all of the special exception uses that are in the code at the present time. Now, the changes that we recommended last time, we had commercial equestrian operation. The committee recommended, or by consensus, wanted that removed totally from special exception.
Right, that's why I was going to ask why that was still here, and then on this.
Yeah, well, I wanted to make sure that everyone was clear on the recommendation, so I put it in as it is now, so we can go back and reconfirm specifically the changes we talked about last time.
This goes back to your earlier comment that we just needed a specific motion.
Yeah, yes.
Well, that's true, and one thing I would say, this is the basic set of regulations we are planning to go forward with. But one thing to remember is, we're gonna have legal review, there's gonna be fine tuning, and this may change to some extent before it actually goes to the planning and zoning board. And if by the time, if you guys are still constituted at the time this finally goes through the town council, they may ask us to bring back a version, so that version may be a little different from what you're saying today. But this is the general consensus as of right now.
So is this where we bring up a motion to say we want to take something out?
Yeah, yes, right. I'd like a separate motion. Actually, I'd like to see two motions. One, to recommend approval of the two sections, section 115-010 and also section 170 that were recommended by the staff for the changes to the special exception.
Which is 170, I'm sorry.
Okay,
That's the
Page
special exception.
Yeah.
Page.
Yeah, that starts on page 10 through 13
Those are the changes.
is article.
Okay, Katie has some, okay, let me ask you this, when we're gonna make the motion here, do Katie and Howard both have something to say? Do we make the motion first, or do we let them speak first?
Well, you can make the motion, get a second, and then have your comments, unless the comments are going to impact the motion.
They may impact the
The
motion.
motion is only over the commercial stables, the motion is
No,
over the...
No.
the whole
All right,
thing.
let's have three separate motions. Let's talk about Article 170 on page 10.
And Madam Chair, I would ask, as you're making each motion, whether you want to include the wording or not, but I would indicate, subject to any further changes as a result of either legal review or, as we go through it, because at this point, this is, it's a draft in progress, but it probably will change to some extent, we don't know yet. So we want you to be aware of that.
And again, we are only advisory, this is, as you said, legal, planning and zoning, and then the town council.
But
Okay.
they, council will have, they're very happy, they might have it come back to you, that's why I
Okay,
indicated.
so the first motion you're looking for is for approval of section 170-10, subject to any further changes?
Well,
Does
actually,
the-
Article 170.
Article
Article
170.
I have a question about that word.
Does that table, is that table included within the 170?
No.
Okay.
I would like to have some quick comments first on pages 10 through 13 in regard to Article 17010, because I do have some comments myself. Okay, Howard, and then, or let's go Katie first and then Howard.
Okay, my question is, page 13, letter C. The 2-year waiting period before you can submit another application. Just seems like a long time to me.
Okay, no, that's in the code now, so, I mean, so.
So is this when we would?
We weren't
talk
recommending
about-
any changes to that, but if you feel that that it should be, then that's something that you can.
6
What do
months
you guys
perhaps?
think?
Why
The idea
is-
was not to have people just duplicate and create the whole process too quickly. You know, if they went for a special exception and it was denied, we don't want to turn around the next day and file another special exception request. That's why the 2 years was there. It was to discourage unnecessary, repetitious actions that have already been dealt with.
But these are cost recovery processes, correct?
They are, but you're actually correct. I mean, I have seen a lot of codes that do what Mr. Ryan is saying, but they're usually 1 year. 2 years is,
Just seems like
could
a
do it to
really
be
long
somewhat
time.
excessive, as you kind of alluded to, so. you know.
So Katie, you're suggesting 1 year?
I would say 1 year.
Okay, so Katie's on page 13 suggesting a change to 1 year. Howard?
Are we gonna vote on that afterwards, or just whether we
Well-
agree with it?
We're talking, we'll make
Okay.
a motion with these changes and subject to any further changes.
Okay, my question,
Okay, Howard, can we finish on that one real quick? I mean, we don't have, we can vote on all of it after we agree to that one thing. So are you okay with it?
yep.
You're okay with it?
I'm okay with it.
I'm okay with it.
Okay, I have a question on page 10 under, I want to make sure I understand this. You're saying category B, looking at this table, requires, it seems to be the best category that requires no public hearings, no timing of notice, no newspaper format, no mail notice, no town council. So a day labor hiring center could be under category B for this table. Require no notice, anything, but yet, the
But if
commercial.
that concerns you, let me just say though, remember what I said, this has to go through legal too, so.
Right.
I mean, there could very easily, you all know what Jim was trying to do with this, but legal may say if it's a special exception, it has to have those things.
Right.
Don't know yet, that's what we're gonna find out when we go forward.
Yeah, and a day labor hiring center is only allowed as an accessory use in the institutional
Okay.
district. So that, it probably would be associated with the church.
Okay, like they are now on
So
Ocean.
right now you have it under commercial.
You have it commercial low,
Okay.
category A, full review,
Yeah, you're right, okay, that's right, it's category A under
full review and commercial low.
Under commercial law.
commercial law, yeah. That's correct.
Okay.
Sorry about that.
Okay, and then again, with the commercial equestrian operation,
We're gonna talk about that.
okay, that's gonna be discussed. So my main concern is on page 10 myself under category C. And I see that, for a period not exceeding 24 hours, unless you have signage or a tent. If you have a tent on your property, then you have to go through special exception.
That's the way it says, it reads right now, yes.
So that's whether you're private or commercial. I thought we had a discussion
Shouldn't
where,
we change that? Let's-
yeah, I thought we had a detailed discussion that we wanted the tent in a 24-hour period.
Yeah, because you're having a family reunion.
That's,
Exactly.
no, I'm not, if I can avoid it, I go to them. Yeah, but that was an example. People bring in tents for their family events.
Okay.
And that was a concern that we discussed. I realize there are commercial ramifications to that, but this seems to touch both private and commercial entities.
And weren't we gonna look for some wording that cubbyholed it into private
That's why
What
I,
functions?
Do you
We
remember
had
what
it-
that was, Mark?
Yeah, we were trying to think what that was. That's, I think, why I'm putting the caveat in, there are still gonna be changes to this. It's not totally the final work in progress. I'm trying to think what it was. I know we had the discussion, and we talked about the fact, I think I indicated, well, even if it's a family reunion, but it's geared toward that individual's particular use as opposed to just a public event where somebody may be generating everybody from the public to come, because the issue is going to be dependent upon what you're gonna do for that public type temporary event. You know, tents, and generators, all that kind of stuff usually requires building official review, which in our case would be Palm Beach County, because of product issues.
We even talked about porta-john and stuff like that.
Yeah, exactly, so, but I don't know, I can't remember what we were
Well,
gonna do.
again, and just to cut it down to the simplest thing, I don't see any differentiation here for private event, you know, a personal thing, and that was
If
our,
we put, I think that's important.
Yeah, there's still polishing to this stuff.
Can we
So-
put something in there?
in category B perhaps, that has nothing.
I would say this, so we're not here till 10 o'clock.
Right.
We're not trying to rewrite it now. I would say, tell us what you want, and we'll try to make sure.
I think we should have some sort of, if it's your little private, once
In
every
section
5-year family reunion type thing.
Just category B, just, which seems to be the easiest one, that if it's for private, personal use, if there's a tent for private, personal use,
On
It should
private
be
property and
under
ag residential property.
I don't think we need to, no, I think we should just keep it
Well,
simple.
the thing is, if you have a church, they can say, well, it's for private church use.
How about
And then here's 200 cars coming in.
this is sounding wrong, but non-regularly occurring.
No, because there's some people who have regular events that it could have done.
Well, I mean, like every year to have a family reunion.
Look, in this town, let's not give many, let's keep it
Let's
simple.
use the example that maybe we can find some common ground.
Yes.
If you're having a party at your house, your daughter is graduating from college, and you want to have a party, and maybe it's going to be some relatives, maybe it's going to be some folks that aren't relatives. I don't think you want the government regulating that.
No.
That's
No,
not the kind of
that's
thing
my
we want.
point here.
That wouldn't fall into a temporary event. But the community of
Even
hope,
if- even
doing
if-
their annual
yes.
Christmas, where they're gonna be bringing the people in, you know, from far and wide, it's gonna be over several days, that is a temporary
Yes.
type of event.
So back
So how do you
to,
define
it's for
You said it perfect. How do you define that? You're the expert at
residence,
this.
is it for residence?
And I'm not gonna try to do it right now, I'm just saying,
Okay,
we'll
so
look.
then how about
If
this?
you want to do it, we'll look at it.
How about this? How about we leave it to where you guys can find the correct wording in such a fashion to where exactly what you said, the
In
family is having
section B.
a special party for,
I think probably the way it's gonna be, and Jim, I don't know if you have any thoughts, but I would think probably what we're gonna have to do is exempt out stuff that's not gonna be temporary, like private parties, things like that. But we'll have to come up with the wording. It might be easier to exempt it out rather than try to.
yes, okay.
Right,
Well, yeah, maybe we can
Birthdays, graduations, bar
put
mitzvahs.
a isn't there a?
so perhaps we should
Wedding.
suggest that we'd like to make a motion to approve this with this, adding a section for exemption. Pardon?
I was just adding to parties like getting out of jail.
Whatever fits your lifestyle. In this town, there's probably lots of those, so
Finally got out of prison.
welcome home.
That would be a
No,
reason to
so-
celebrate, I'm sure. Yeah.
Section, okay, so the motion would be to approve Article 170-10 with changes by adding a section for exemptions that would cover things such as tents for personal use on personal, for.
Well, there we would actually list weddings.
Right,
Religious events.
Yeah, to list the events, that's
Festivities.
what we're trying to get it to specific.
Not-
less than
Non-public.
24-hour period.
That wouldn't encompass more than 24 hours.
Yeah, you don't want to start getting into mentioning tents and things like that, or you're gonna, that's gonna be real tough.
No, I wouldn't put tents, I would just say a personal event or family, or private event that would be less than 24 hours.
There you go,
Now,
private event, I think that's the
Yeah,
term
a
right.
private event.
Yeah, private event.
But they don't have to get rid of the stuff within 24 hours. In other words.
No, yeah, I mean, if you have a porta-john sitting there and nobody's using it, I don't think that should be an issue.
Okay, so
Private
that's.
property, private property.
You want to say private outdoor events, because that's.
That sounds good. Private outdoor events.
And then we also have, with the exception of Kate, page 13, changing section C to 1 year.
Right.
So let me try and say this motion again. We have a motion to approve Article 170-10.
I had a comment.
Oh, I'm sorry. No, I thought you
110.
made your comment.
No, I never did.
And
And that wasn't 10, that was 15. I
Okay.
wanted to comment on.
Okay, well, we're just on 170-10.
Right,
So,
that's
okay,
what
so
I
we're
thought.
good
No,
now?
just one, Article 170, the whole thing.
Right.
We're not gonna go through section by section.
Okay, so yes, go ahead and
Okay.
comment then. Okay, so
Okay.
you had said -10, that's why I was.
I'm confused a little by the wording under C.
On where?
Yeah, I can see where you would. be.
Okay, I mean, including, first of all, including is misspelled, obviously, that'll be corrected. A property/building layout with dimensions from the town manager stating that all applicable provisions of the code are satisfied. This to me says that the town manager is responsible for making that drawing, and that's not what the intent was to my
How do you feel
recollection.
about that, Mark?
Well, I
Nor
feel
did
about
he
that.
want to be put.
That's gonna be changed.
So can we we're gonna change C to, how would we do that?
Well, whoever's doing it supplies the drawing and the layout, and Mark just reads through it and approves it. That's
Yeah,
all.
Jim and I have talked about, I think I mentioned this to you, previously. I'm not thrilled with regulations where where the town manager or some official in the government is always waiving things, because that is ripe for problems down the line. But Jim and I have talked about different approaches, and we may end up staying with that, with a minimum, there'll be very few things, I think. Or we can also incorporate some criteria that they would have to meet that's more like a concept plan and not a site plan. I think we talked about this, the concept plan doesn't get into the amount of
It's more
detailed, detailed specifications and things that you would find on a building set of plans that will really get into the specifics of the use. The concept is generalized. It gives you like a site plan, but not a site plan in the true sense of a site plan. It's just more or less generalized.
Mark, let me ask you this. When I look at C, and if you change some wording here, basically, in building, usually you submit your prints and your documents, and then you get a confirmation from the plan reviewer that everything meets code. So is this saying a zoning confirmation letter from this town manager stating that all applicable provisions of the code are satisfied?
You're gonna have to ask Jim that one. I'm not sure what happened on that. I think there's some words missing.
It looks like something's transposed.
Yeah, it looks like
Well,
words are missing.
The wording that we had originally was for category B special exceptions, a zoning confirmation letter from the town manager stating all applicable provisions are satisfied.
Right.
And at the meeting last month, the committee wanted to see a drawing or map accompany that zoning confirmation letter. So maybe we can put that the property and building layout should be prepared by the applicant.
Right.
Not by the
So
town
the
manager.
confirmation letter could just simply have attached a 8x10 or a legal
Yes.
to the confirmation letter, confirming that the confirmation letter is confirming this layout. I mean, that's standard
The
procedure.
zoning confirmation letter is prepared by staff. The layout is prepared by the applicant.
Right.
But there's some reference in the zoning confirmation letter that the attached layout represents what's going to happen.
Right. So this is, can we just transpose that then? Special exemptions, the zoning confirmation letter from the town manager stating that all applicable provisions of the code are satisfied and includes
a property building layout with dimensions
Supplied by the applicant.
supplied by the applicant, yeah.
Yeah. Okay, well, we'll get, yeah.
Yeah, that's to
Yeah,
be
we know
subject
the
to
gist. We'll get it.
changes, okay? That just looks like it was transposed from what the standard procedure you guys usually would
Including
follow.
a conforming property building layout with dimensions supplied by the
Okay,
applicant.
just to be sure, any questions on section 170-20? And Mark,
Yeah, just a wording thing.
what page?
Page 11, under 170-20B, right at the end, shouldn't it be a notification to the town council? Or
tended to be up.
Under 17020?
Yeah, under B, the last line, last
That-
full
I mean,
line.
I certainly have no problem with that.
Require the authorization of the town manager and notification.
To the top, it says of the town council.
Yeah.
Existing special exemption use require the authorization of the town council. Category B, special exemption uses are the modification of existing special exemption requiring the vision of the town manager and notification of the town council. In other words, the town council needs to say it's okay.
No.
But
No,
is
no,
that-
town
is that
manager.
correct?
No, that's what-
Then you don't have to have
Yeah.
words in here.
Yeah, that's right. What we, with the category B special exceptions, it's essentially administrative.
That's the simple one.
Yes,
Yeah.
yes, okay.
And then we're just gonna put it on the council's consent agenda as just like a list of things that the manager did this past month.
Right, that's the purpose of
With
doing this.
notification of
Two.
two. Notification.
Two.
Yeah, that's fine.
All right, any other? Okay, let me try saying this. So you're looking for an approval of Article 170, special exception uses. You're looking for a motion for approval of Articles 170, special exception uses, which we are giving, noting the following changes that we would suggest. That under Section 170.10, we would like to see a list of items that are exempted, events that are exempted. If that is not, that's what we would prefer to see. If there's an issue with that, then we would like to see under category B, some type of wording for private events, a period of 24 hours that will require very minimum notification. Under section 170.15, we've noted that there's a transposition correction. Do I need to restate it, or can say
No,
previously discussed? And then on section 170.20, the minor notification to the town council. And under section 170.040, item C, upon denial of an application for a special exception use, there shall be a 1-year waiting period. And this would be subject to any further changes by legal and any other town contractor.
I second.
Well, she didn't pass the gavel, so somebody's gotta make, she just
I make the
stated a
mo-
very nice motion. Do you wanna make that your motion?
I'll make that motion.
Okay.
Okay, all in favor?
Aye.
Aye.
I'm
Okay,
not
Josh.
sure repeat it.
I have a question. Signage. When people hold barbecues or birthday parties, they have a sign that says, birthday party here.
We were gonna exempt.
We're not talking
all
about
those.
that, right?
We're
But-
looking for the exemption for
That's-
personal.
So they would be exempted from all this list.
That is what we
Okay.
clarified, and that was fact, but we went, John, we all went into detail on that.
Right.
So the motion passes 5-0. A little concerned about all the changes that'll be done.
Is that coming on the next month's deal? We get to go over those changes?
And let me
Now,
just
we're
say
gonna
something.
we're gonna give it legal, we're gonna work on everything, and then it's gonna go to P and Z action.
Okay, but let me just note something here. I mean, we've made the motion and I went through all that wording, and I did not, in that motion, reference the issue. We've already previously discussed the commercial equestrian operations, that we want that.
That's a separate motion, isn't it?
Yeah.
That's
That's a
gonna be a
separate
separate motion. Okay, I wanna make that clear, that that was not included in our motion for reasons. Okay, second motion you'd like to discuss?
Would be on section 115-010.
115
010,
page
page 15.
15.
That's the public notice requirements.
And you would like this to be approved, discussed, reviewed, which we,
Well, recommend approval as as shown on pages 15 to 17.
Yeah, let's just look it over one more time. Anybody have any comments, please let me know.
Yeah, the abutting properties, the need to mail a notice to abutting properties. That means, first of all, personal events are going to be omitted from that anyway.
Right.
We hope they will be, but they may not be, that's the concern.
Okay.
So, you know, if special exception B is gonna be very minimal, maybe,
Well, what we're going to say essentially is that those personal events are not included in the category of temporary events.
what is the purpose of the mail notice? Now, when you say mail notice radius, could you just clarify what the purpose of the mail notice is? It's not asking permission, is it, or is it just informing them of it?
That's informing them that there's going to be a public meeting held by the town council, at which approval of a proposal is going to be discussed, and if they have any comments.
Wait a minute, that's special exception B? Because that doesn't require public hearings.
Oh.
Well,
Uh-huh.
that's why I was saying, depending upon what legal says, because we're using the term special exception A, B, and C.
Right.
If
Plus
legal says special,
exemptions.
you can't, we might have to come up with different terms to describe B and C because of requirements of
Right.
the law, okay? So generally, there's three forms of advertisement that, I mean, under normal circumstances for land use decisions. Usually it's the notice in the paper, it's the property, it's the signs on the property, and then it's the mail notice radius depending upon how far you go. It varies, some cities do 300, some cities do 1,000, some do 500, but it's identifying three different ways, and then of course, if you have a website like the town, then there's a fourth one, but you can list it on there, so.
Yeah, that's true. In this case, it would be just notice to the abutting property owner that the abutting property owner could, if he wanted to, contact the town manager with any concerns that he had. Or if, when it's placed on the town council agenda for receive and file action, he could stand up and make a comment at that point.
But again, let me ask you this, on special, what we're calling special exception B now, there's no mention of anything involving the town council.
Yes, it's placed on their agenda.
Even though you're not saying here, you put required public hearings, you put not required, the town council is still involved?
Just in terms of getting notice of what the manager's decision was. But if you go back and look on page 10, on category B,
Okay.
the town manager has the ability to elevate that to a category A. So you notify the property owners, they go and talk to the town manager. If there's some serious concerns, the town manager, based on those concerns, has the ability to make it a category A rather than B. So it gives the abutting property owners some input into that decision process.
Any comments? Okay, Beck's away from the table, so let's wait for Beck. Any other? So we're just looking for approval of section 15.010. Table of public, so any other comments on table of public notice requirements? Okay, so we are noting that special exception D, even though it's supposed to have minimal requirements, the mail notice that is mailed out to abutting properties, those people can approach the town manager and he can elevate this to a section A issue. So, just making that clear out there, so I'd like to make may I make this motion or does someone else have to?
Pass the gavel to the vice chair.
Katie,
I make a motion to approve the
section 15,
section 15-010.
with subject to any further changes? Would you like that included all
Yeah,
somewhere?
please use that language, that way we're covered.
Subject to,
If there's any other changes.
I'll second that.
all in favor?
I,
Aye. approved 5-0. And I will just make the comment, you're asking us to say that it's subject to any further changes. What is the purpose of saying that, if you could clarify? Just
Okay, I'll give you one example.
because it makes me
Normally
question
special-
why we're sitting here.
Normally, special exceptions require a public hearing, there's a whole process by law. And what we've done is, when Jim has done an A, a B, and a C, in terms especially of trying to, the category C, which are temporary events, are usually handled, in many cities, they're called temporary permits, they're called different things, they're not really a special exception. However, for some reason, our code had lumped them together originally. And what I'm saying is, obviously, we don't want public hearings for all three of these things. So the way we may, and we have to talk legal, the way we could probably get around it is calling them something else and not a special exception. That would probably be the easiest, quickest fix, I would think.
Okay.
Those are the kind of things, we haven't had the chance to have legal reviews, so that's why I'm saying, you're giving your blessing to this in concept, but there probably will be some changes that will have to be made when it gets to the P&Z board, town council, and then possibly back to you.
Okay, so we are finished with 3A1. Okay, at this point, I would like to point out, Mark had the agenda sent out with a note that the rest of this information is basically for a review this evening. We are not to get into it in depth, is my understanding.
I'm going to give you an overview on the,
Right.
we're going to give you
Mark-
overviews and
So
then,
Mark and Jim are going to give us the overview.
I think we need to go over the
table.
table, the special exception.
Oh, I thought we didn't do
No, we did
three.
not.
I apologize. That's why I asked if we, so we weren't done. Okay, thank you, Beth. So we are not done with 3-1A.
Yeah, let me start out by going over the changes that you recommended at our last meeting. Under the agricultural residential district, it was consensus that commercial equestrian operations be stricken from requiring a special exception at all. Okay, that was first change. Mobile homes under the agricultural residential district. The mobile homes were originally in the zoning code as subject to chapter, Article 80, conditional use, but you went to Article 80 and there was no conditions for a mobile home, even though it was referenced in the code. So the council changed the reference to conditional use to special exception. So the town council passed a specific ordinance directing that mobile homes be subject to special exception approval. So I'm not sure if you want to recommend that it go back to the way it was when the council already addressed that issue and said that they wanted it to be a special exception.
Wait a minute, is what you're saying that the town council, we do have an ordinance that deals with mobile homes, right?
Yes, it was originally a permitted use in the AR district, subject to conditions in chapter 80. But you go in chapter 80 and there were no conditions, that was just left out by mistake.
Yeah, I think the idea was, and this was pretty thoroughly discussed, that we did not want to encourage mobile homes and mobile home parks, but it was recognized that the county's practice of people temporarily living in a mobile home while they were building a permanent residence was okay. And, you know, I think that the concept was that there was, you know, going to be a requirement for a septic field, you know, other things that had to be approved in the special exception process was appropriate to do that. But it was up to the town council to make a final approval on the thing.
Which they seem to have done.
Yeah, they wanted, they changed it to a special exception, but conditional use, in my mind, may be the better way to do it, because you can put in Article 80, if you wanted to require that it have a septic tank and a well, you could put that in as conditions for approval. As a special exception, don't really have a list of items that shall be considered. So if you wanted to to go back to conditional use, I personally think that that's fine.
What impact does this have on the town, the fact that there's an ordinance that's existing?
Yeah, well, what the town did was essentially took the easy way out. I mean, there was no conditions in the code, even though it said that there were, yeah. So rather than go back and write a list of conditions, it just says, okay, we'll look at it as special exception.
But it doesn't even have to go to the town council.
We did have to go to.
No. After saying that it's a special exemption, if we look at mobile home use, it goes to category B.
No, that was
Which
the
means nothing.
change that we made, but
Right.
the ordinance was calling for it to be a special exception.
Yeah.
Full special exception.
A full special exception and.
Which category on the special, like the whole?
Be like A.
Yeah, that's
For
right.
you.
That's right. There's only one category of special exception now. And
This is what we want to change it to, I'm sorry, yes, sir, okay.
That's right. The mobile home would have to go through an entire site plan review process now, as a special exception, as it currently exists. If we said,
As conditional
if
use?
it goes back to conditional use, we're gonna have to revise Article 80 to put those conditions in the code, which are not there in the first place.
You know, this is my recollection, that there was a pretty good consensus, as I remembered, among the town council, that they didn't want to open up Waxahachie groves for mobile homes. And the idea was that the special exception process let the elected town council make the decision on any specific thing like that, because there are representatives. And if they didn't want mobile homes out here, they would have a list of conditions on a special exception that they felt were reasonable. And one of them might be that it not be there longer than 12 months or 18 months. I mean, I think where the concern came up is that we've got some real violations where property owners are putting travel trailers and mobile homes on their property for rental without adequate septic tanks and wells, and, you know, they're just behind us in Florida Holly. And I think that the council wanted the ability to go in and say, you know, that just is not permitted.
Yeah, that's true. I mean, it becomes an issue of, do you want it to be a conditional use or do you want it to be a special exception?
But there were no
that's really the
conditions
question.
to where we.
Yeah, that's right. We would have to write the conditions if it's going to be a conditional use.
But I think
The way it is now, it has to go through the category B, special exception.
When we talk about mobile homes, we're not talking about RVs.
No.
We're talking
Are we
about
talking about
permanent
modular
structure.
buildings?
Probably so.
My recollection was there was some state statute, I think where they dropped off the cliff and never made the conditions, was everything John is saying is accurate. But then somebody from the audience chimed in, from the public chimed in, who knew about this stuff. She was a land planner or something like that, and basically said, according to the state, you can't prohibit mobile homes. You have to do it in some way. And I know Dennis was upset about it and this and that, and that's kind of where the whole thing just wound up getting frozen, and they never moved any further.
So conditional use would,
there was a problem with conditional use, because it got to be so many conditions that, you know, were hypothetical, that they didn't want to try and write it. They wanted to review it in detail and make a decision. You know, because it'd be different if you had a 5-acre property and you wanted to put one mobile home on it.
For you to live in, and it's your property.
Or for your relative to live in, your mother-in-law,
What if you wanted it as your own house?
or your own home.
Yeah,
You know,
that's
but-
why it came up.
may
But
I
they didn't
ask?
want to encourage that.
Let me ask something from both Mark and Jim. I'm trying to understand this. So you're telling me that for a mobile home, which would be a permanent mobile home residence, the town council would have to approve it based on the ordinance they created?
Yes.
do they have to approve if somebody wants to build a home? This seems to be coming
No.
under, because it seems to be that, it just seems to be, I'm kind of baffled why it's even a town council issue. They don't approve homes.
Well, let
They
me-
don't want mobile homes.
Oh, I understand they don't want mobile homes.
Here's, I think, where you're getting on the slippery slope here. But the way town is doing it is backwards from the way most communities do it.
Right, that's
Most
what I believe.
communities have, because ULDC is basically zoning. And zoning was adopted to protect private property rights and valuation of your property. The indiscriminate placing of mobile homes can impact property values. You may not like a mobile home being next to you if you have a beautiful, 3,000 square foot house and you're saying, oh my God, this is going to impact my property value. So what most communities do is they provide for mobile homes by virtue of putting them, they designated an area or a zoning category, and they allow mobile home parks or mobile home subdivisions. As Mr. Ryan indicated, the town actually went the opposite way and said, no, we don't want those, but we'll allow placement of mobile homes subject to then other criteria that they had to put in. But I think there is, I think the planner that you mentioned might be absolutely correct about that. You gotta be real careful. Because I mean, that is a basic, right, and if you're not going to, put the regulations in place and you gotta be careful. Now you're,
Okay, so Mark, if you could continue, and if you and Jim could then continue that discussion, is this where we get into the issue of the conditional uses situation, or do we just stay with these
Well,
sites?
I think the biggest question right here is does the state say you can't say no? If the state says you as a town cannot tell somebody that they have 5 acres that they can't put a mobile home on.
I'm hesitant to say that because it might not just be state, it might be federal.
And so
then
that's subject to
can we-
legal, that is, so this is illegal, this is subject to legal review then,
Yeah.
is what you're telling us. We
Exactly,
can't
and let me give you another
inform
example,
on this.
not that I want to go for mobile homes, but let me give you another example, because Jim could not have this in here. Tuesday night, I'll use Big Dog, it just happened, Big Dog Ranch as a rescue animal care. If you notice, it's only listed under AR. But town council pretty much went with a recommendation by the planning and zoning board that they would like to see it on Southern and Okeechobee and have a 10-acre minimum property size. That means that to do that, we're probably going to have to allow animal care as a special exception in commercial low. And I don't know about commercial low office, I have to think about that. But, because now if you're going to orient them to Southern and Okeechobee, and this, I think it was raised by Councilman Golsonade, if I remember correctly, Jim, the idea is, if you're going to direct them to Southern, are you going to want them to have an AR designation? We were looking at Southern as being our commercial corridor. So now you set up a whole other set of issues, and that's why I'm saying this is going to have some changes based upon legal ramifications.
Right, and
We're
it
gonna have
seems
to
the
have
mobile home issue is based on the questions that Beck has just brought up, is so I don't think we should be commenting. I think this is such that we're, in our motion here, we need to just understand that the mobile home issue our
Let me-
suggestion is it needs to be reviewed.
And let me cover one more thing, because you asked a question that we didn't address, I think, and that is you asked about conditional and special exception. You generally have four general categories of use in any zoning category. You'll have permitted uses, you'll have conditional uses, you'll have special exceptions, and then you have prohibited uses. All right, the permitted uses and prohibited uses, I don't think I need to go any further. We all know what they are. The difference, though, between a conditional use and a special exception, they're both forms of permitted use. However, the conditional use is something that's permitted as of right, subject to you meeting any number of conditions that are enumerated in your code. Could have 5, could have 10, could have 2. As long as you meet those, you're fine. The special exception goes one step further and requires the public hearing aspect.
Now, that's where I think
It doesn't
the
mean they can-
sense of the town council was that they wanted to look at it on an individual basis because they weren't comfortable with writing just a standard set of conditions that made it of right.
So then that's why it fell, and that's probably then why, if that's the case, then that's probably why it fell into special exception.
That's why it fell
Yeah.
into special exceptions.
But is that legal?
Except the special exemption that Jim put it in was category B, where it doesn't take.
No, we don't want that.
Yeah.
So we wanted an A.
Yeah.
Wanted an A.
Now, is there still
Well, that's-
someplace in the ULDC that allows you to have a mobile home while you're building your home?
Yes.
Okay.
Yeah, most regulations allow that, whether it's commercial development, residential,
So those are temporary mobile homes.
Sure.
They're not,
Well, if it's a big commercial site, usually it's a watchman, it's security plus
but those are all temporary deals. What we're talking here is a
permanent.
permanent
Yeah.
mobile home.
Now, I will tell you this, part of the reason that the council directed us to look at special exception was, and this was back in the summer of 2011, that there was a property owner that wanted to put a mobile home on his property, and he found out that he was going to have to go through this very expensive process just to put a mobile home on his property. And that was the impetus for the council to look into special exception in the first place. So if we put mobile home back into category A,
It gets really expensive
that,
again.
that's essentially putting it right back where it was in the first
But then
place.
it keeps going back to where, is it legal or illegal, whichever way you want to look at it? Is it legal to tell them no, is it illegal for them to do it?
I think the discussion was that they can't prohibit it, but they wanted to be able to look at each individual application, to look at it in detail. And if somebody wanted a permanent mobile home there, they wanted to really take a look at it, look at the site plan, the whole thing. I mean, I think people could complain about it, but I think that short of prohibiting it, we ought to leave it as a special exception because we can't write all the conditions, all the setbacks, you gotta have a septic.
Well-
Yeah, but special exception A, it's very costly.
Jim?
Here's one of the issues though, and this gets into the comp planning, there's a housing element, that's one of the required elements of the comprehensive plan. And then it goes further, and one of the things you had to indicate was how you can provide for low moderate housing.
We satisfied that. Statistically, we had so many low-value homes here, we qualified for that.
Okay, but I'm just saying, but that generally, mobile homes are considered in that category, and that's one way.
We had so many low property value, small houses, that we did whatever percentage was required to not make that a problem. Because we were
But
considering
it's not,
that
I'm sure
workforce housing.
it's not based on property value though, it's based
Well-
more or less on income. and
It
that
was
kind of
work, income. We got a lot of people out here that don't even file tax returns. And it was workforce housing concern and mobile home concern. And the planners took the statistics out here and satisfied that we didn't have to have a special.
Jim, I don't want to put you on the spot, do you remember in the housing element what the policies say about mobile homes? I guess that's gonna be, we'd have to,
Can we have a category D?
let me look, I have my plan here, while you
Okay,
can go
well,
on and I'll look.
what I would
So we go with category D that's not cost prohibitive.
Yeah, we probably could, but what I would suggest is let's, make a motion recommending that
Your table.
that we table, yeah, but we could relook at that issue, the mobile home issue, because really the only, the text amendments that we've already recommended approval.
We look at the issue of mobile home.
Yes.
Yeah, because we're gonna be looking at each of the individual zoning districts as we go through the process. And these uses came out of the list of uses in the zoning district, so we can look at mobile homes when we take a specific look at the AR zoning district. So rather than try to resolve it tonight, which it doesn't appear like
We're gonna be able to.
we're going to be able to, just make a motion that we look into the issue of mobile homes when we get to looking at the AR district. And then,
When we get into looking into the AR district, you
yeah,
said?
yeah.
Okay, let me just, we do have one public comment, I just would like to take, if you could make it short. Kevin Garreau?
Yeah.
Regarding fifth wheels and mobile homes?
Yeah, I just wanted to make sure that people understood the difference between what a mobile home is versus what a fifth wheel is. Mobile home, you can't move. Once it's placed into place, it's really not supposed to move.
Correct.
But if you have something like, you go on vacation and it has wheels on it, and you put it on the back of your dually, that's considered like a fifth wheel.
Right.
Those move.
Which we use the word permanent home.
Okay, So when you're talking mobile home, I was unclear because yes, the federal law does allow, if somebody is a building contractor, they buy 5 acres. If they want to put a mobile home on that 5 acres while they build the home that they themselves can build, they are allowed to by federal law to do so.
Right.
Okay, so that mobile home exclusion is allowed. The other thing is about fifth wheels, which maybe some of them were talking about, is whether or not people are doing that. I know for a fact during the equestrian community, there are people that come from out of town who are either, I don't know what you call them, horseshoeing people,
Those are RVs,
horse
though.
quilting people, but they have their own fifth wheel. They park on someone's property to do that work during the season, and then they leave
That's an
6
RV.
months, 8
Yeah.
months later. I just want to make sure people understood the difference between mobile homes.
Those were,
And I don't know which one is the more of the problem for the council or less.
those are considering as recreational vehicles, as the RVs, and the
Right.
mobile homes are like what you're talking about, that they're strapped down on blocks and like.
Yeah.
This is gonna have to be studied, I just found we may have a disconnect between our ULDC and our comp plan.
That's it.
Our comp plan policy,
Thank you.
I'm sorry, Kevin, I didn't.
No, I'm done. I
I'm
just
sorry.
want to make sure they knew.
The policy 6.2.3 says, provide for innovative housing alternatives, for example, single-room occupancy, accessory residential structures, caretakers' quarters, groom quarters, manufactured and mobile homes, and congregate living alternatives oriented to facilitating reduced housing costs for very low, and moderate income households and special need populations. So if you start making this mobile home a special exception, you're not really complying with that policy.
Right, which I also made a comment to Mark and Jim at a separate point, which I did not get to express to everyone here, I don't think, but when we were going through our definitions, my concern was we had said, let's take out groom's quarters and caregiver's quarters. I had concern about that because one, as Mr. Harris pointed out, the groom's quarters makes a difference between whether a barn is habitable or inhabitable. And so, again, just as a point of comment, when we go back to review things, we might want to keep certain things in. We might want to look at the significance of what having those definitions are, especially with what Mark is telling us tonight.
Okay, now we do have a definition of mobile home in the ULDC now.
Right.
Which is a structure transportable in one or more sections, which is 8 body feet or more in width, and which is built on an integral chassis and designed to be used as a dwelling when connected to the required utilities and includes plumbing, heating, air conditioning, and electrical systems contained therein. Now, we talked about revising that definition a little bit when we talked about definitions, but this is pretty clear that it's supposed to be a residential unit.
Yes.
Okay. All right, so again, the motion you're recommending, since we've gone back and forth here, and Mark has now brought that to our attention, that a special exception may contradict that.
Good.
Jim? So what would now that Mark has made that comment to us, what would be the suggestion for the motion? Do we just relook into still the issue of mobile homes
Yeah, well,
when we get into
I would
the AR
like,
zone?
I would like to see the recommendation be that the uses on the table on 14-29, with the exception of commercial equestrian, which we recommend be stricken,
Right.
that list be adopted, recommended for approval, but that the issue of mobile homes be further addressed when we look at the
Rescued animal care, subject to necessary.
Right, with the final statement, subject. Anyone else care to comment on that?
Would it be 2 motions? One
One
to
motion.
strike the
I think
commercial
that's a good
equestrian?
idea.
Oh, 2 motions then?
I think that's a good idea.
So
I
that-
make
what
a
would you
motion to
suggest?
strike commercial equestrian operations from special exemption categories by zoning district in the table of 14 of 129 on the agenda of 6/20/13.
Yes, that's the first motion. Okay, anyone opposed? Everyone in favor?
Aye.
Aye. Okay, that motion passes 5-0. Second motion?
That's the one.
Yeah, the issue of how to address mobile homes be further researched when we look at the AR district.
So are we gonna do another two motions, one to do that, or one to just say, we accept the table, and then we're gonna look at, but you were talking about something about the rescue thing. Can you elaborate on that?
Yeah, when Big Dog Rescue.
Because that's not on here, right?
No, but because of Big Dog Rescue, they requested a change to accessory aspects of their use. Because rescued animal care is a special exception in the AR district now. Okay. When it went through a review to Planning and Zoning Board attached two conditions that council embraced. The two conditions were one that it would have a minimum parcel size of 10 acres. And the second is that when located, well, let me take it back, I have to explain this. One of the reasons for the text amendment is that the Big Dog Ranch Rescue, proposing the amendment, wanted to have veterinary services and boarding kennels added to the rescued animal care for dogs that they adopt out to people. So in other words, you adopt something out, but then something happened to the dog, and you need to come back, they can do the vet care. The P&Z's motion added that if the rescued animal care located on Southern or Okeechobee roads, they could also entertain vet services that have nothing to do with the rescue, with the adopted dogs, and boarding services not having to do with the rescued dogs that were adopted out. So they basically made it available to the public, yes, exactly. Okay?
And that was their original request.
Yeah, so what ended up happening is, the council embraced that and said, yeah, we would like to see this kind of use locate on Southern or Chubby, primarily Southern. And then the discussion came, well, wait a minute, that's, for the plan and everything, that's our commercial area. So what I'm saying to you is, we only have it as a special exception in the AR, we may have to look at adding it into commercial as well.
Well, I think it makes a little sense to put it in the commercial, for the reason that they're gonna have that general veterinary type business
Right.
involved in it.
Right.
And not so much in the AR, though we have vet clinics within the AR, and they bounce back and forth, but the veterinary clinics that we have in AR,
Historical.
Yeah.
historically speaking, are burden and horses. They're agricultural animals, not domesticated pets, and I know there's a definition for that word, so I apologize for that, but.
Okay, so Jim, the recommendation that you're looking for in this, but again, subject to any further changes.
Yeah, okay. The first motion was to recommend approval of the list with the exception of striking commercial requesting.
And that's,
Right? Okay, that's passed. So the second motion would be to
Regarding the mobile home, we look into the issue of mobile homes.
yes, when we get to reviewing the AR residential district.
Would anyone like to make that motion?
I'll make a motion.
Howard?
I'll second it because I think we've got to deal with it.
But we need to read, someone needs to say that, read that, say that, I mean, Jim has told us the motion, and we need to
I make a
verbally
motion that we look at the mobile home
issue of mobile
issue
homes.
when we address the AR district.
Okay,
I'll second that.
subject to any further changes.
Yeah.
Okay. Any, all in favor?
I,
Anyone opposed? Okay. Howard, you didn't, okay.
I made a
Yeah,
motion.
you, okay, sorry, I really,
You're gonna say no.
I didn't have any beer. Okay.
there's,
Approved 5-0. Motion passes.
there's some that building down the road.
Okay, we are now going into, finally,
Do we need to address what you were talking about, the big dog thing, right now, or is that something that's being,
I
hasn't
think
been
we'll
brought up?
look at it, we'll probably look at it and
Okay.
address it.
okay.
Okay.
Now, we've completed 3A1, and at this point, again, I will make the statement I was making before. Everything from this point forward, it is my understanding that has been submitted, we're going to review, we're not going in depth.
Well, committee member Ryan provided a number of information on noise, and I don't know if we need a big discussion tonight, but I guess we need to ask him his intention, and,
Yeah, my intention was that this was a thoroughly discussed issue. And all the way from the Florida Constitution through federal law, through Environmental Protection Agency determined levels, through Palm Beach County, through some of the state departments, through an advisory attorney general opinion, through articles on enforcing noise ordinances. I thought that all of this was background related to our existing performance-based ordinance. And that if we wanted to talk about it, I felt this was supporting keeping the ordinance that we have. We've got all kinds of related state statutes that deal with right to farm, but with respect to noise, I thought that rather than just have a lot of personal opinions, we'd go ahead and have a set of materials that are fairly straightforward as to what these noise levels are that are in our code. And it was a code section that was very thoroughly discussed as part of the ULDC. And I even included something in here that was a survey of the workshop that was dealing with this, which basically said like 73% thought that regulating animal housing such as dog kennels or exotic bird aviaries is very important, and 90% of those thought it was important to regulate outdoor animal housing for noise reasons. So it was thoroughly discussed, and I'm not even sure why we're dealing with it, because we've already exempted everything that's subject to other state statutes.
Well, without going ahead and rehashing, the reason why I brought it to you a meeting or two ago was because the gentleman who, from Quest Technologies, who provided the training on our noise meter, indicated that the provision that we're working under is not state-of-the-art, based upon analog and digital. And all we did was say that at the appropriate time, we will look at that regulation and make the proper modifications. Now, I appreciate all the information you provided, because we'll look at it for certain.
Right, so we
But
weren't
that was
tabling
3 years ago too, so, when you did all that research at that point in time. And without getting into specific cases, we just had a situation that occurred yesterday at the special magistrate where you can see that there is a conflict in the provisions of the.
That's a Scribner's error.
Well, I
Okay,
would wanna.
Let me just ask this, then. We have this information. You said you were gonna bring something to us. Can we,
No, you've already taken a motion. The motion was that we will go ahead and we will revise accordingly based upon what we need to do. There was a second motion that I believe Mr. Bourne made it and indicated that please make sure we look at the county and their regulations when we do this. So I think that's pretty
And I
clear.
put that information in.
okay,
Yeah.
so this is information.
This is good
for us to
information
have.
to
for
have this
reference.
research material.
Virginia, can I interrupt real quick?
Yes.
I,
No, you're
and I know you,
interrupting, you're speaking, go ahead.
and I know you've got some up there, but we had this issue happen 2 months ago.
Right.
There's 3 gentlemen here. I don't know if they wanted, but I know they're here. I'm guessing, are you here for public discussion as well?
Well, I just wanted to add some comments.
Well,
here.
did you
Okay.
fill out a card?
Yes, I did.
Is
Oh,
there,
I'm
and I don't know
sorry.
at what point of the agenda they were going to, but I'd hate to do what we did in the past, where we left somebody hanging, so.
No, and to that, let's correct something here. You said item 3A2, which were there, but what I'd like to do very quick, and you're gonna make this quick, okay? I missed, and this is my mistake.
I just don't want to leave them hanging like
Right,
we
you're
have
right,
in the
you are
past.
correct, you are correct. And I missed, Keith had an additional comment. Very quick, very brief, please.
Very quick, I appreciate you. Motion 5-0 to remove commercial equine operations from the special exception use, but it's hanging out, out of the special exception review process. It's still hanging out there. Should, perhaps, in my opinion, perhaps the motion should be amended to say that it is to be considered as a permitted use. You've taken away from the special exception, but you didn't put it anywhere.
Yeah, and I thought that was our original discussion, I believe, at the last meeting.
If we take it out of special exemption, is it a permitted use?
Yes.
By definition, yes.
Well, it could be a permitted use or it could be a conditional use. but you
So we
say
would
that.
have to clarify that in the
So
motion.
do we need to clarify that within that motion or make any motion?
If you have an opinion and you want to say it, certainly.
Because that was the discussion, I believe, was that it was a permitted use when we went through that 5-0 last
Do
time.
we agree that it's a permitted use?
I guess so.
Well, I'm asking you, that's why.
What else do we have in
Conditional
Article
use.
8? I don't
You
have
can make it a
Article 8.
conditional use,
And then we have to set
In
conditions.
which
for it.
case, yeah, you set conditions for it, but it's permitted, as long as the person meets the conditions. But the problem with the conditional use is it requires cost recovery.
Right.
With the cost recovery?
Cost recovery, so that's becoming a very controversial issue lately, so.
That's why we said permitted use.
So
We were
permitted would-
very
yeah,
clear
permitted
last
would
time
not-
We had this discussion, and thank you for bringing that back to our, we omitted that, maybe perhaps going back, we need to correct that motion. And since it was your motion, Beth,
Do we correct the motion or do we make another one?
we amend the motion, amend the
You
motion.
could amend it.
Amend.
With the second and the no motion would have to, the person who made the motion would have to agree, and then you.
So I would like to amend the motion that it would be a permitted use.
That commercial equestrian.
Commercial equestrian would be a permitted use.
Denise, who did the original motion in the second?
I.
Katie seconded that motion.
And you made the motion.
I made the motion.
Okay, so you're both agreeing, okay.
Mhm. Okay, can I have this one again? This
From
motion?
the very beginning,
Mhm. The amended motion.
make a motion to remove commercial equestrian operations from the special exemption categories by zoning district on page 14 of 129
Yeah. I think
of
that's.
the ULDC packet of 6/20/2013 with an addition or amendment
Amendment.
that would say that it is a permitted use within the ULDC.
Okay.
Do we need to vote on it again?
Second.
Second it.
Okay, all those in favor?
Aye.
All those, any opposed? I did, John, I didn't hear you.
He said aye.
Aye. Okay, motion passes, amended motion passes 5-0. Thank you for that clarification. Okay. So we have John's information that has been provided to us for review on the noise, I guess, and I'm acknowledging that we're saying we have received the information from John in detail. You also, at the previous meeting, we're going to, in future detail, bring more information forth, is that? Or it's not really necessary?
Probably not, I mean, we have the direction, and
Right,
I've got it
there's-
back off, I've even communicated it to council at this
Okay.
point, so we'll be doing a summary for
So
that.
the
with everything.
council, yes, there's a summary coming before the council, so basically, it's done, and then we have a comment from Larry Lefkowitz.
Thanks. Actually, I prepared some additional information for everybody, so I'd like to just give it to you.
Okay, that's fine. You have a copy for Denise too, right?
I'll give it to you after.
For my records,
Yeah.
yeah, for the minutes.
This is in addition to what John put together. And I'll try to, John said a lot of things,
All right, John's usually
which I'm
very
not going to
thorough.
really necessarily repeat. Just to say that,
Excuse me, his name and address?
Oh, Larry, okay.
oh, sorry,
You have
I'm
to say
Larry
your name and-
Lefkowitz, 3485 D Road.
34?
85D Road.
I saw the playback of the last meeting and I wasn't here, and I just wanted to make some comments on some of the things. Basically to say, as far as the noise levels go, the noise levels we have now, as you know, were inherited essentially, or we use the ones from Palm Beach County. And as far as like what levels would be reasonable or good or, make sense for our town, any town, one thing is there's a tremendous amount of research out there on noise levels. And a lot of it is based on scientific research. The EPA has done it, the World Health Organization has done it, and it basically quantifies what kind of noise levels actually affect human beings in an adverse way. And I've included in some of the documents I gave there, the recommendation from the Environmental Protection Agency as far as what those noise levels are, and they happen to concur with the noise levels that we have now, So those are objective things based on scientific fact. And if the noise ordinance is there to protect people, essentially, this is some information. This informs us on how to protect people, at least psychologically and physiologically, from damage from noise. But there's a couple of other things that I wanted to share too. The psychological and the physical are documented in some of these reports, and I gave some links there where you can look at a lot more of this material. It's a tremendous amount of material out there. We don't have to guess at it, And also, but there are some other ramifications which may not have been discussed.
Howard, I'm trying to turn it off.
I apologize for Howard.
Which are,
I'm just gonna answer it when we listen to the meeting.
okay. Well, I just wanted to say, like, this whole thing with the Big Dog Ranch pretty much shows pretty clearly that people do not want to be next to sources of sustained and, repeated noise, And when you buy a piece of property, you maintain it and pay your taxes, you have the right to use it and enjoy it as you see fit without unreasonable intrusions. And regarding the problems that happen to people when there's this adverse noise, there's a reduction of property values if you have a source of noise like this next to you. And if a remedy is not available, then the person may decide to sell their house. And possibly at a loss because it's hard to sell when there's a source of noise next to you. Or
They also have the option to sue their neighbor for that loss.
Exactly, that's the other thing I wanted to get to. So when I'm talking about financial issues with noise, you're looking at the reduction in your property value, you're looking at the incredible upheaval of having to sell a house that you don't want to sell just because you can't remedy this noise situation. Or you can mount a lawsuit, which can easily cost tens of thousands of dollars, if not more. How many people can really do that? There's not many people that can do that. It's extremely prohibitive. And then also that doesn't factor in the lost time that you have having to deal with this noise problem when you could be doing other productive things either for yourself or for your family, and income producing activities, etc. I just wanted to share that because I don't know if that's been covered. The other thing is, there were some things mentioned last time about public versus private nuisance, etc. I can give you my opinion, but the Palm Beach County ULDC, the current Palm Beach County ULDC, they have their table of noise levels. And then under that, they have public nuisance, injunctive relief, any emission of noise, the generation of sound from any source in excess of the limitations established in or pursuant to this chapter shall be deemed and is hereby declared to be a public nuisance. So they're basically saying, the Palm Beach County ULDC is basically saying anything that, is in excess of the noise listed in their decibel table automatically becomes a public nuisance. But here's the thing, everybody is protected by the Florida Constitution. Everybody has the right to be protected from excessive noise, And especially in Loxahatchee Groves, which really has a totally different property density than most of Palm Beach County, it's really easy for one person to be affected by noise and not have other people affected by noise, And that person, we have objective criteria for noise, which is, listed in our, decibel level. It's not some kind of subjective thing. You can't really get away with it. You can't really make a false noise claim because you just figure out if that noise is there and then, then that's it, And so you can't always get two people to make a complaint on noise. And there's some other reasons too. Well, first of all, requiring two people to make a complaint is like telling someone who is assaulted by their neighbor, please go home and we can't help you until your neighbor assaults somebody else. It just doesn't seem right, And then making it more difficult, I've actually talked to people who have given me some reasons why they will not make a noise complaint. And one person said, I'm afraid to make a complaint because I'm afraid of my neighbors. There's plenty of people who will not make
There's
complaints.
complaint, and there's other reasons they have fears not to make complaints.
Yeah, and the other one is like, I'm afraid of ridicule, I'm the victim, but I'm being blamed. I've heard that. And one person once told me, I don't like the noise, but I want to keep making my own noise, so I'm not going to be making any waves, you know?
Okay, I thank you for this information, and I think, Mark, you've said, this is, oh, go ahead, I'm sorry. what
Can I
was
just
it?
say one more
Yeah,
thing?
because it's been well over, it's almost going
No, I
on
just
9
wanted to make
minutes.
one more comment
Go ahead, real
related to
quick,
what
please.
Mark brought up, which is this noise meter thing. And I looked at some of the counties that, the noise person, the noise trainer had brought up as examples. One of them was completely off the hook. I mean, they didn't even have any noise levels required, you know? They didn't have any decibel levels, they just had some, it was very, very, obtuse kind of stuff. But basically, it may really be helpful to, I work with a noise expert, and he is up on the latest technology and how these things work as far as being able to quantify noise levels. And there's new technology that's very inexpensive, you know. It's basically an iPad and special microphones, and it's actually more, it's ANSI level 1. It's, we require ANSI level 2, this is ANSI level 1 stuff, you know. So it's even better, better qualified, and you can really do some amazing stuff with it, because you can take, what it does is it records all the noise, it records your L10 levels, it records your L50 levels, your L90 levels, all automatically, digitally, right in front of your eyes, you know. And there can't be any issues, because the sound, you're recording for hours on end. You can record the sound at the same time as these levels. So if there's any issue with whether there was some other kind of noise coming in, like lawnmowers or airplanes or whatever, you can just go to the sound and listen to it, you know.
Okay, so,
Can you just give that to Mark?
I can give that to Mark, yeah.
Yeah, if you give your copy to Denise, we'll have it.
right, and then again,
Well,
Mark-
no, I'll have to give you what that technology is.
Okay, that's
Yeah.
fine.
And then my only comment on this matter, then I'll ask Mark to make a final comment on this issue for us. But my only comment regarding noise issues in this town, because I enjoy peace and quiet, but I also respect other people's rights to have businesses, etc. I also expect the town council to enforce codes equitably and not make excuses that they can't afford to pay for noise monitoring while we spend excessive amounts of money elsewhere. So I would, in regard to this noise issue, my only comment, I don't think it requires a motion, it's just simply a comment to pass on, is that, however you call this, enforcement should be done equally across the board. No favoritism should be involved, as I will quite bluntly say to you as the town manager and as a member of this committee, I feel there's favoritism going on in this town where noise monitoring is not being done as a favor to other people. That's my only comment. If you have anything to add to this, then we can continue on.
Sure. You want me to respond to your comment, or just in
No,
general?
just to come to the noise, no, just so we can wrap up the noise
Well,
section and go on.
all right, from the standpoint of enforcement, we have tried to enforce it across the board fairly for anybody who has raised a noise complaint. There are a lot of ways you can handle it in addition, but each case is different depending upon the respondent and the individual who's making the complaint. And so that's where they differ to some extent. I will say that in terms of, I don't disagree with Mr. Lefkowitz. There certainly are new technology coming out and everything, and a lot of it depends upon what special magistrates will entertain when you get into that quasi-judicial setting, and what they feel is going to pass muster in terms of going ahead and getting the evidence you need to move forward on a case. From a general standpoint, I will also tell you that in all the years that I was involved in code enforcement, probably the three toughest cases that end up costing, that become quite costly for the government, are overcrowding issues when you have a complaint like that, because it forces your code people to do surveillance, to watch the goings in and out of a property. When a church is operating out of either a home or whatever the case may be, and a neighbor complains, it again gets you into a monitoring situation, because a lot of times the the person will say, well, I'm not conducting a church, I'm just having a Bible study. That's all we do, we come and we do a Bible study. So you get that kind of situation. And the third one is the noise, because of the fact that you have to take readings, and depending upon what the situation is, sometimes it's not going on when you have the inspector go out there, so you end up having to send the inspector multiple times, and then make sure that they are getting positive readings. And so having just said that, those are the three and noise is a tough one. It's not as easily done as some people would like to think, but
So we're not,
nevertheless, we'll be happy. What we want to do is we want to amend the code to reflect state-of-the-art situation.
so we're not here to make a motion on this issue, we're just here to acknowledge,
Well, I think you've given us direction already. so-
right, we,
But I'm very happy to take any information that, Mr. Lefkowitz will provide us.
John has
Yeah,
provided.
Member Ryan has provided a whole bunch of good information, so,
Okay.
sure,
So can we proceed then on to the next,
we can.
on to 3D new business?
Thank you.
Thank you, and again, just this, as Mark has stated, is for review, we're not here, we're just here to review it, we're not here to make motions on this.
Yes, let me clarify that. Madam
And so
Chair.
you'll
What I indicated, you have a very large agenda tonight, and the reason you got it late for a number of reasons, which we had some technology failures, but nevertheless, what I wanted to do is, we have 4 items here, and staff wanted to give you a quick overview of these items, and these are really, the information is really for you to take back, digest, look at, and then at our July meeting, we can start to really get into the meat of it. But let me give you the first one. You see, it's the flood insurance rate maps and floodplain ordinance. And without giving you a long presentation as to what's going on, what has happened is communities have been waiting for new flood maps. It's been like, I think, almost 13 years since new flood maps have been issued by FEMA, by the Flood Insurance Administration. And what has happened is, you have this in your packet. This is the new map that we received. It's not the official maps, but it's one that a consultant from West Palm Beach provided to the League of Cities. And as you can see, where the town wasn't in the flood zone previously, almost 90% of the town is now projected to be in the flood zone.
So we need to buy North and North Road.
Yeah, I get you say that. So, there's a couple of different things going on. The League of Cities has had a couple of different meetings, and they're going to continue. They may form a consortium to try to, or some kind of body to represent the cities, but it's been very clear that each individual city needs to go ahead and look at its own flood maps, and I do have a big set that was provided to me by FEMA. Roughly, we did a conference call with FEMA on June 4th of this month, and it appears we're going to have about a 90-day period in which to review our maps. And so luckily we're in the process. We hope on July 2nd we will have contracts ratified by town council for our own engineers, so we can have our engineers look at the hydrology and make their determination, so we can go back and be part of this effort and address the situation. But FEMA plans to say, FEMA's given us roughly about 90 days. Then there is a 90-day public outreach period where they're going to meet with all the cities as groups and individual cities, and then they do some public outreach where, as an individual, if you're going to question what the designation is on your property, then they'll talk to you as well.
How did, or maybe you can tell me, I don't know, maybe I'm interrupting too soon. How did FEMA come up with deciding that these areas were flood zone, flood areas?
They
Well,
scan us
they're
during
doing
the
all of them.
hurricane?
They have consultants that they have. The consultants aren't local. I think they're out of Atlanta, is what I've heard.
And are they using previous information as well, or just like what has happened in the past 2 years?
I'm not sure all the data they're using. We're questioning what they're using,
Okay.
because I know it seems that all the
If they're using the last 2 years, we're SOL. If you're using like the past 10 years,
Right.
it's
Well-
really not that bad.
Well, and John, yeah, and the other question I would have is, obviously, you're working with the Water District on this, or?
Steve Yohe has joined me.
The district actually has a flood basin
Data.
study that was done several years ago.
Right.
And the whole idea is that we want to argue that the canals, if they're permitted to reasonably drain into C-51, should be adequate to handle the kind of rainfall that, is a problem now.
Just ignore last year?
No, we were exacerbated by the natural area.
Oh, thank you, John, get it in there.
In any event, yeah, the answer to your question is yes, I am working with Steve Yohe. Even though the water districts aren't actually, surprisingly not, they weren't part of the conference call, it was just the cities, we're going to
How
work
could you
together.
not involve them? Okay.
Anyway, so, one of the issues involved with this is, as you know, Florida writes the most flood insurance policies in the country, and then Palm Beach County writes the most flood insurance
Oh,
policies.
this is cha-ching for the insurance company.
Well, the problem is there was a
The
law
flood insurance
passed.
company is the United States government. But go ahead, I'm sorry, I apologize.
There was a law passed called the Briggers Waters Act that I think it was passed last year or the beginning of this year. The flood insurance people have been in arrears in terms of they're not solvent right now. And so, some folks think that this is an effort to, try to get some solvency to the flood insurance program.
Well, only if you have a mortgage, right?
What it's gonna be is generally if you have to go for a mortgage, because right now, your insurance policies don't cover flood, believe it or not.
No.
And the only entity who gives you flood insurance is the federal government. So, and if you are in a flood zone and you're getting a mortgage, chances are you're going to probably have to get the flood insurance. It's going to affect, it's not just us, Wellington, Royal Palm, everybody is under the gun for this, so.
Calorie
Yeah, exactly. So, we're gonna be looking at this, and we're gonna be seeing if we can, change their minds in terms of the data and what they have. The reason we gave you the flood model, the FEMA model ordinance, is because this was something we provided to council last year. Mike Cirillo provided it to me. Generally, if we are in fact found to be in a flood zone, generally the next step you have to have the floodplain regulations, because that talks about proofing of, how you waterproof your homes and those kinds of things. And it will be a big administrative, unfortunately, in trying to keep a government light, this won't be government light. This will be, putting a floodplain ordinance in that we're gonna have to administer.
Right, Jim.
And they don't exempt farms. There's no right to farm exemption for.
So we wanna go over it so you can see what it entails. I know, council, when we brought it to them, I think there was so much stuff in that first packet, that's why they said we need a committee to start to sort through this.
Right.
So that's really what we're gonna be doing. I will be able to keep you updated as to what's happening in terms of the city's interaction with FEMA.
And this is basically dictated then by the conversation between FEMA and the cities then. This
Correct.
is just for us to be aware.
I think the League of Cities want to get involved, and in fact, Jim gave me a name of a gentleman who actually has a pretty good track record in working with FEMA. He has some modeling that he's done in the past. And I mean, anything that can help, help us change FEMA's mind and for the ultimate flood map. So I passed his name on to Richard Radcliffe, who is the executive director of the League of Cities. The bottom line is the new maps will not be, it'll be another year before the new maps are finally out, but that's after we go through this process. So now is the time when we have to interact with FEMA and work on these things. We're just trying to be a little proactive, show you the kind of ordinance, because this is the FEMA model ordinance. And I think then we also provided some Palm Beach County information as well, so you can see. So
Right.
we're saying kind of read through it, and next month we'll start to get into that a little bit and talk about it. There's a lot there, so I apologize for that, but.
All right, and then we're on to the ordinance 2000.
Yes,
Two.
pain clinics, let's talk about that for a second. That's-
Can you tell me the page for that, please, sir?
On pain clinics, it's,
Or the next thing we're looking at?
It says 76, I believe, it's 75. Oh, no, that's
No,
Palm
it's
Beach
farther
County
back.
model ordinance, I'm sorry.
it's,
Yeah, there's a lot to read on that flooding, isn't
it
there?
starts on 115.
No,
115?
for the-
115.
Yeah, and all the items in between is the flood issue.
Okay,
What is the Palm Beach? Oh, that's
Pain management.
pain management. Okay, what has happened is the town did an ordinance and a moratorium. The ordinance is number 21003. It was adopted on March 16, 2010, and what it did is it imposed a zoning in progress declaration of moratorium, which is not repealed, surprisingly, until new land regulations are adopted by town council. When the management company came on board in 2011, we saw this and went, uh-oh, we've inherited this. Normally moratoria have an end. It's not continuous like this. So I don't even know legally if we're still okay or not, but the ordinance called for town administration to examine and make recommendations to the town council. Such regulations would not be imposed until the town amended the ULDC to address these issues. So we brought it to council with the big packet of information, and council, you know, as it, is basically sending it to you as part of the ULDC. So this is one I want you to take a look at again. Again, I'm not asking for action tonight. I mean, this has been, it's been kicked around, it's been in place for a while now. We don't think that there's a lot of areas for a pain management clinic to go, although you don't want to look at Southern because, you know, that is going to be our main commercial area. So, you
And
know,
does this, I want to interrupt you because, again, is this in the same concept as when you discussed strip clubs with us and you said it's better not to prohibit something, it's better to manage where they can go? Is that where you want us to be thinking
well,
when
that is
we're
true
doing?
too, but I know our current state attorney now, Dave Ehrenberg, when he was working with the Attorney General's office, this was one of the areas he focused on. And there have been a lot of progress in terms of the pain management clinics and what they have done in terms of cracking down on them to make sure that, you know, they don't have these places operating pill mills, that kind of stuff. But I'm not really even sure, I totally understand where council wants to go with this. And I think probably the input from you guys would be very helpful in terms of figuring out what we do.
Can you get us the information of what Ehrenberg is doing on all that, so that we have more of that information on how?
I could probably get that.
What
You know, he did-
limitations they added or said, or?
I
or
think
adjusted?
he did provide that to the Luxembourg Groves Landowners
He
Association.
did.
And you have a copy of that by any chance?
When was that
No, I
provided,
don't, but I'm
John?
sure Marge would. But the background that I remember on this was that either Ehrenberg's office or Palm Beach County, we got a model ordinance to adopt because there was just a general sense that South Florida had a big loophole that allowed the use of drug pain management clinics.
Right.
And we were encouraged, I mean, we didn't pick this up out of the blue. Somebody came and presented it to the town council. And there was discussion over the fact that we didn't want to encourage this in our commercial area.
Well, there was a period where I think all the cities were being encouraged to do some kind of moratoria.
Almost like a League of Cities thing.
Exactly.
Does this
But
not
we
fit
haven't,
in the
but
medical-
unfortunately, we haven't done anything with it, and we probably should have.
Does this fit within the medical stuff, in the medical?
Like with the consultation?
Like the hospital deal, or like this deal
At
going up
Fro-
next door
Well,
here?
it's kind of like a pharmacy, pharmacies that are not really operating within the full spirit of the laws. They're, you know, they're dispensing.
I understand, but I mean, they can't, like they're building this medical building next door.
He's talking like a legitimate pain clinic, not a phone. You're talking about,
Well,
Well,
I
we-
don't, I mean, I don't.
there's legitimate
Yeah.
pain clinics that deal in therapy and rehabilitation.
These do not fit within that, within the medical.
I don't think what's going on over here, this is just strictly offices, I believe. I don't think there are.
Well, I thought there would be medical offices.
I'm not aware, you know, clinics, are they gonna do clinics in there?
No, as far as, I talked to the owner last month, and he said he's got a pre-leased, there's two stories and one tenant for each floor, medical. And that-
I see, medical is,
That's
does
all
that,
we
does
told
that
them.
fit, does this fit within the medical deal? I mean, if a doctor has an office there,
And that's where we'll have to review it.
Yeah, see,
and
that's,
come up
now you're
with
getting
wording.
into the, yeah, that's an issue.
That's where you're asking for the additional information.
that's why I don't,
This came out at the same time that some people in Wellington went to jail
Right.
because they were operating, you know,
No.
essentially.
And they weren't doctors, they
Drug
were,
distribution
yeah, they were,
centers.
you know, it's the, almost like the middleman of the, you know, they get involved and they,
well, can we get more information on what the laws are from the state?
yeah, well, I'll see what I can find, I'll see if I can get that stuff from
Okay.
Amber and
All right,
Attorney
so
General's office, and we'll look at that.
moving on then to 3 ULDC, Article 87. This
Article
one-
87, native tree preservation, soil stabilization, and invasive exotic removal. This came up, we had a couple of different issues,
Who brought this up?
who brought it up?
Yeah, I'm just, where did this one come from? You said we had issues.
Well, we had some issues with trees being girdled by the horses, and we were trying to, that was it was a code enforcement case that actually got put on hold.
That's not, okay, I was just, all right, that's okay.
But what it was is, in reviewing it, I guess there was a committee that was put together during the time by the town environmental committee.
Well, that's what I was wondering.
And and you have in the county, who generally handles this stuff. I think, and this is pretty, we did a comparison, this is pretty close to the ordinance that the county has. However, we were looking at this and we found there's some typos and there was some more important references in terms of DBH and things that were wrong. So when we took this to council, council kind of said, hey, we need to make sure we look at this, make sure it's okay, make sure it's really what we wanted to adopt. And so, again, this is something, that we can talk about and go into greater detail, but if you can, review it on your own and then be ready to talk about it next meeting.
And then I'll just, we'll go through it, because I'll have a few questions just top of mind. I believe, two things. One is that if you're ag, there may be some confusion as far as if you have exemptions or not for specific trees. So I'll go through this, but I'll probably ask you for that
Sure.
information.
Sure.
And then the other one, does the Department of Environmental Protection, usually they're more for wildlife and animals, but does the Department of Environmental Protection, which I realize we don't have anything on our website, but landowners are supposed to know about this themselves, did it have any impact on this section?
It could, there may be some, I have to go back and look through it again. But I will tell you that from the ag standpoint, the environmental regulations are the one area where, ag could have, does not have the get out of jail free card.
No, but I know
You
there's
can't
some
create
things on
hazardous
the,
conditions with your ag,
right, there's some, but I think there's some things on the state book that that may have been
On the tree
revised.
removal side, you have some right to forestry.
On which side is it?
On the ag side, you have some rights to forestry.
But I think that there may be an acreage.
The
that may be
size,
a-
I don't know, I
That's
just,
why I'm asking you
Where-
for
oh,
additional information.
If I remember the committee meeting, one of the big issues was people that came out and said, hey, I want to be ag, and they just cleared the property.
Right. That's
And then
what,
they didn't do any ag.
right,
They just wanted to sell it as a cleared property, which
Right.
was approved.
or like the developer who has the fire.
And we dealt with that based on a performance guarantee equal to 110% of the cost to restore native vegetation in the event the ag use was not implemented.
That part I understand. My concern was just the issues, when we look at this, just have information of Department of Environmental Protection, if there's any impact from them whatsoever, and then any other ag, state ag, because we're always talking about state statutes here, just if there's any information on state statutes
I
that
think
may
we're
be.
probably, we will do that. I think we're probably okay, only because of the fact that this reads pretty closely to what the county has, so I would think that, the
Oh,
county
you
hasn't
trust
had
the
problems.
county, dude.
I do.
wait, is this what's
I
in our
know.
ULDC, Mark? I'm sorry, is this what is in our ULDC?
It is,
Yeah.
it's Article 87.
Okay, that's why you're asking us to review it.
Right.
Absolutely.
Okay, and
And then the last one, we don't really have any backup with this, but the issue that Jim was going to get into earlier, the discussion of vermiculture and other ag issues. Jim, take it away.
he's been waiting, huh? Go for it.
Where
What
is
page,
this?
Jim?
Where is this?
No, there's no backup.
There's no backup, I just wanted to,
There's nothing here. Okay.
Otherwise,
just wanted to bring it up and discuss it. Howard, before you came in, I made a statement that we had, I guess a couple of meetings ago, you asked me whether or not a property could get the bona fide ag designation based on providing a business plan. And I had mentioned that I had talked to the appraisers before, and that it was my opinion that they couldn't. They told me that you couldn't. Well, with the change in administration at the property appraiser's office, which went into effect in March, and I had a new head ag person, I called over and spoke to a guy named John Butts. I don't know if you know him or not. He's one of the two ag appraisers. And he said that the county will not give a bona fide ag or an ag classification based on a business plan. You have to be up and running and show your tax receipts and things of this nature. So that in my mind leaves us with a gap. On a vacant piece of property, if someone wants to do an agricultural business, he cannot get the bona fide ag classification until he's up and running. So there's a time period in between startup and designation. And my my question, I guess my dilemma is, due to the fact that there is this gap, does the town now have the authority and the right to require site plans and approvals on new ag operations during the startup period?
Well, let me ask you this question. From what I understand, and you talked, when you go to the county wants to find out if your property is gonna have the ag designation. They ask for a Schedule F. If I were to move here from Wyoming, and I have an agricultural business in Wyoming, and I have filed Schedule F for X number of years, and I show up and I buy this property, and I say I wanna make this ag, and they say, well, approve, well, here's my Schedule F. Which the Schedule F is the agricultural scheduling with the IRS.
Okay.
So if you have that, 'cause I mean, you show up in June, or whatever, say in the middle of whatever their months are, you say, here, I am ag, here's my business, my business is raising emus or ostriches, here it is, here's my proof. Can they not build their ag buildings, proving they're an ag business, though the property they just bought was not bona fide ag?
That's a question I certainly can't answer, but I would say that if you give them documentation for a business that was located elsewhere, I would be surprised if you could get it here on this.
I understand, but you're transferring the business from elsewhere here.
So you're saying that they will know, based on your conversation as of March of this year, they will no longer accept what Beck has just outlined?
No, I'm not saying that they won't accept that. He told me that they will not accept a business plan
A plan.
as the basis to grant a.
Right, but he's talking about an ongoing business.
Now, I mean, I didn't ask him about the situation you're talking about. If they have all of the business papers and the IRS returns filed on a property located somewhere else, can they just transfer that here?
Or a business located somewhere else. I mean,
Yeah,
Right.
I don't know the answer to that, but.
Here's an example, Jim, and you don't even have to move from one state to the other, but Altman's is already here on D Road. Okay, they've got properties with existing businesses, so they keep buying up all of D Road. So that's a perfect example to give this gentleman, well, what if they buy the property next door, which has not had anything on it, but they have an existing business? Will they automatically get?
Yeah.
do they have to do the site plan? I don't think they should.
Yeah, okay, but that's the issue that staff has been struggling with. Do we have the mandate or the right to require site plan approval on properties that do not have the bona fide ag classification at this point? And
Well, what if like 6 months, let's say they start today and by the time they're done with the building, they do meet the ag rules, then, I mean, they're within that jurisdiction. If they don't, then they're in trouble then.
You know, it almost.
But recourse, does the town have to come back and say, well, wait a second, you built a strip club?
Yeah.
You know, you're not building a horse barn or a cow barn, you're building a strip club. What recourse does the town have?
I think there's two issues here. The first is the new administration from the Palm Beach County Tax Appraiser's Office is, according to the opinion of some, acting against the intent of the Florida Constitution. This is a decision of the new administration. That has yet to shake out as to how long they're going to continue to be allowed to get away with this, whether they're going to be legally challenged, whether anybody's going to bring them to court. I would submit that the way things are now, anybody could get around that. In other words, perfect example. If you're going to have an agricultural enterprise, you could do the things that don't require a building or a structure or anything like that. You could fence in your whole place, put horses there, go down and say, okay, it's fenced in, here's the horses, here's my business plan. Then after you get that ag classification on that 10 acres you have fenced in, then you can go ahead and proceed to build your barn, your stable, your feed facility, whatever else it is. Okay, so somebody can go in the front door or they can go in the back door.
Let me give you an example though to your comment, Howard. I recently heard from somebody that lives in our town that has a 5-acre property, has a barn, and the ag people, as of last year, came out and did not give them a complete ag exemption on their 5 acres. So you're saying, just fence in your property, throw your horses on 10 acres, and you'll get a complete ag exemption.
But did they have a house on it?
Yes, they do have
So
it.
they took off?
Yeah, they took up actually for an area that should have been used, as could have been called pasture, but or exercise area, it's no grass in it. So these people at this agency right now, there seems to be a lot of inconsistency.
Absolutely, you gotta know to push back and you gotta know to say,
But
I know somebody that
what Jim's asking is how do we as a town deal with that?
Right.
Yeah, and the main reason that I'm bringing the issue up in the first place for us to think about is that we get very strange requests almost daily at the town hall. Can I do this? Can I do that? What approvals do I have to get? We have what's called a zoning confirmation request form, and somebody comes in and they have a use. They write down this use, and then we do an analysis of the code, and then give them our opinion as to yes, they can do it, or they can't, or they need to get these approvals. Let me go over the most recent one that we got, and
Are we gonna laugh?
you probably are. Okay. This is the owner of a chain of restaurants in Palm Beach County. He wants to start a vermiculture operation. Vermiculture, which is a worm farm, and bring the food scraps from his restaurants out here to feed and grow the worm farm.
Which will turn into compost.
And then use the castings, which is the worms residual
Right,
waste.
which is very safe, clean.
And then use that as a soil amendment to grow potted plants and a strain of corn that's not in evidence in South Florida, because he claims that Publix drives the corn products in South Florida because they're the biggest purchaser, and he has demonstrated he wants to grow. So
Florida only grows corn.
He wants to.
Publix.
He wants to do, yeah, that's exactly.
Not for the rest of the country.
He wants to do, and he also is proposing that he bring out his residual glass products, grind up the glass into sand, and combine that with the worm castings to use as a soil amendment on his corn crop and his potted plants.
So you have two
He-
parts to that almost.
Yeah, that's right. He came to us and said, can I do this? And do I need to get any permits to do it? He has a site in mind, and I'm not going to go into any details. This site is in an area where there could be considerable concern on the part of the neighbors about potential smell and vermin control as well as trucks bringing in the waste. Now, do we have the right to require this guy to go through the site plan process and be subject to public scrutiny? Or do we say he's a permitted use, go ahead and get your building permits?
And by the way, Jim wanted to bring this up, I said, this is a wonderful case to bring to you. These are some of the things that we deal with. You would not be surprised what we get
Every day
sometimes.
we get things like this.
Well, let me ask you a question, because if somebody wanted to put it in a hog farm, isn't there a kind of a rule that if the neighbors bitch about it within a year, they can say, no, you can't put it in a hog farm?
Well, there's a limit
The
on.
right to farm, well, that's the right to farm act.
But I mean, if you come right up next to my house and go, oh, wait a second, you cannot put 60 sows, right next to my place because it's gonna create a huge stench and environmental issues, blah, blah, blah. Don't you as a neighbor say, well, you cannot do this, and I have a lot of time to create
And
a
that's-
complaint about it.
Yeah.
Would this not fit within that same, I don't know if worms are within agriculture, but I would guess they are.
We got an opinion from the agricultural extension office that vermiculture has been declared bona fide ag.
But
Okay.
not the sand,
The,
not the glass being converted to
Well-
sand, that's not.
well, we talked, yeah, that's true, but that would be an accessory
To
use.
the agriculture.
Yeah.
The accessory use,
And
even though it
we
wasn't
talked
ag.
to the solid waste authority, and they said that
How
they-
big of restaurants does this guy have to bring up that much glass?
he's got several.
You gotta have the whole mess put up, but
I
okay.
think he's gone into the garbage business and he wants to turn us into a dump.
Do you think?
I think.
Well,
You're on it.
well, what his long-term game plan is to sort of look at this as a prototype and then eventually expand it into a much larger operation elsewhere.
Let's send him out to Belgrade.
Can he sell the glass that he turns back into silicon? Can he sell the silicon to the glass manufacturer to remake?
Well, here's the thing.
I suppose he could.
Here's the thing is let's take it, I mean, should somebody like, I mean, it sounds like a great idea.
Well, first you have
But
to
a
use
lot
the
of things
budget.
sound like great ideas.
Wow.
I mean, really and truly, I mean, come on. Everything sounds like a great idea, a lot of things sounds like a bunch of BS, but what recourse does the town have if he doesn't do that? If all of a sudden it turns into a big dump?
Yeah, well, that's what I'm saying.
Can the town say, okay, get out of here, we're gonna dig a big hole, bury all your stuff, and we give the property because by that time he's broken?
If we have a review process, or he's got to get a site plan, we can ask conditions, number one. And we can also identify penalties and other actions on the part of the town if he doesn't do what he's allowed to do under his approval.
I mean, right now you can have, who's got the 100 acres over here on B Road? You got a bunch of cows turned out there. You can get a bunch of supermarket waste or citrus pulp
Yes.
or whatever and dump it out and feed the cows. And
Because they'll eat
I
it.
hate to tell you, but it stinks and the cows will eat the snot out of it and you can't tell them, no, you can't do that.
That's their
Well,
feed.
this individual is cooperating, he's trying to get.
I mean,
What
this
if,
is-
what if somebody came in and said, it's ag, I can do it,
Well,
you know?
let me,
Well, if it is, he can.
let me say this.
Okay, but I'm just saying, you know, that's.
All right.
But not if you can't get bona fide ag until after he's in operation. That's what I'm saying, we have this gap. Should we take advantage of that gap to try to control
No.
these operations?
No, because I would like to know what the state has to say about if somebody comes in with an ag business, what we can or cannot do. And if they're really and truly, because it would be like if somebody fenced in a property and threw a bunch of goats out there, or a bunch of cows, or a bunch of emus or ostriches out there, and you're gonna tell them, no, you can't turn those birds out there, you can't turn those cows out there.
What the state has said is that it's up to the property appraiser to determine whether it's.
But they won't do it until you get it done.
I understand, but it's the property, this is where the state does not have a whole lot of rules and court precedents established. The state says, if the property appraiser says it's bona fide ag, then they accept it as bona fide ag under the state statute. They got one state statute that says right to farm under nuisance. They got another state statute that says what the Department of Agriculture can do. And they got another state statute that says it's up to the property appraiser to determine bona fide ag. Now, I think on that basis, you've got a gap that you could require this thing as a special exception or an experimental farming operation that would have to at least go through a process that would include notice to neighbors and go through a site plan and do the special exception A.
But the first thing is, you have to put it in the code as a special exception.
But then I'll have to disagree with you on that,
Otherwise,
because
it's not
they have
committed
they have a
use.
cost
It's
issue
not- it's not
associated
a
with that,
question.
with something that, if it has to do with that, why should they have to pay to be?
Okay, so how about if this guy gets his property, fences it in, has a business plan for one ag business, throws cows on there, and then he says, okay, now I'm gonna fight ag, so now I'm gonna start my worm farm. I mean,
I don't think you can take a bona fide ag for cattle and make it a bona fide.
They don't-
ag
they don't-
for
they-
horses.
they don't describe what it is.
You can change your ag designation.
Your designation does not say cows.
You
Or
know, the
beef.
issue
It
now
says on the
is
question, but it doesn't say on cattle.
that
Right. It has a different breakdown.
It's just
Right.
agriculture if it's cattle.
No.
They have a different breakdown.
They've got
It doesn't, it says livestock.
Cows and.
It's not called that, but it's cattle grazing is one.
the issue now is that individual tax appraisers' offices in different counties make unilateral decisions as to what is ag and what is not ag, regardless of what is in the Florida Constitution. So you can get the Florida Department of Agriculture specifically stating that a worm farm is agriculture, yet on the other hand, the Palm Beach County Tax Appraiser's Office can say, we're not accepting it as agriculture. Now, that doesn't mean that that worm farm loses the protection under the Right to Farm Act. It doesn't mean that it is not considered bona fide ag. It just means they don't get the tax protection in the county. Now, as John pointed out for years, okay, it's a taxing authority. And I've always argued against that. But however, the way things are evolving now, it's turning out the state is saying this, and that is bona fide ag, regardless of what the individual tax appraiser's office from the different counties decide to do on their own. We can't control that. They're a taxing authority that has nothing to do with the Florida Constitution and the Right to Farm Act. They are supposed to react accordingly, but if they don't, the state is not going to go after them. It's up to the individual people within that county to go and sue the tax appraiser's office to make them fall in line with the Constitution. Hence, you have this new regime, which you just mentioned, which is changing all kinds of rules in the hopes that they'll never be legally challenged. Okay, so again, the problem is that you can still go ahead, if we as a town make something too difficult to do the right way, people will get in the back door. As Katie said, all they got to do is go become an agricultural enterprise. And now, if you go ahead and say, well, wait a minute, you got your bona fide ag because you're grazing cattle, and now you have added another agricultural use that according to the state is bona fide ag, which is a worm farm, and you're doing all this other stuff, we're going to cite you for not issuing building plans. That's a shaky foundation to stand on, because the state does consider it agriculture. You can't, in my opinion anyway, go to a magistrate and hold that landowner responsible for building a barn without the proper building plans, because he got his bona fide ag for cattle and now he's doing it to raise worms. He built a building to raise worms. Okay, the opinion you got from the Attorney General says what it says. So you got a problem there when you rely this whole thing on the tax appraiser's office now at this point.
All right,
But I'm gonna feed off of what Howard said, and we were talking about this earlier, and you hadn't gotten here yet. You said you can run agriculture without being on bona fide ag.
What I said was that we have, in our zoning code, in the AR district, we have, as permitted uses, we have agriculture and we have bona fide ag. We have two separate.
But you told me you could run an ag industry on a property that's not bona fide ag.
Yeah, of course.
Yes.
Yeah.
So then what are we arguing about?
You don't
If
have to
this
go to
guy's
No,
putting-
what
if this guy's
what
putting-
we said though, if it doesn't have best management practices, we can regulate it.
Yes, so
I don't think vermiculture has best management practices, I may be wrong.
I don't, well, okay, and on that point, that's fine, but you were bringing this up as an example. Now, we can go back to the worm farm later to put regulations on it, but going off of that if they do have the BMPs and all that stuff, then you said there's that gap. Well, there really isn't a gap, because if it is an agricultural business, whether the property is bona fide ag or not, they're still protected within the agricultural statute. There really and truly isn't a gap.
Well, here's the thing, you
Is
hit
that
the nail
correct?
on the head with the BMPs. With the
No?
BMPs, without BMPs,
Oh.
you are allowed to make regulations that are not written or covered by the BMP. It doesn't matter whether they have BMPs or not. Anything that's not in the BMP, the town is free to regulate as far as the industry is concerned. So you can regulate it, but you cannot regulate it to the point of making it prohibitive to do. Therefore, in this particular example, you cannot tell him he can't have a worm farm, but because there are no BMPs, you can tell him that he can't have a glass grinding facility.
And let me add to that, another example.
But can we require that he
Can have enclosure, like for his composting. Perhaps you can say, most composting with earthworms to be effective and productive, they have to be enclosed. They can't be having rain constantly come in on them. They have to be at a certain temperature to be effective to live, because the earthworms are underground usually. They only come up when it rains, and too much rain kills them. So things like perhaps certain enclosures, the odor doesn't come out of that. There's probably more odor out of manure than there would be out of those things. And those are things that you mandate. And as far as, worrying about rats, you've got water in Florida, you've got rats, unless you don't know what you have
Unless
around
you got a
you.
gun around all the time.
Pardon?
Unless you got a gun around all the time.
Virginia, you got a worm farm?
No, I'm just saying it's organic composting.
Well, let's say
It's 4-H does it. The kids
Let's
try to
say-
sell it to you all the time.
let's
So
say
the
he
way
just
the-
has the worm farm, can we require him to get a site plan
For what?
for the worm farm?
For having a few bins?
If
If he's agriculture, no.
Well,
Okay,
if
you can't require a site plan for a worm farm. You can require a site plan for any activity that requires the housing or storage of garbage, or grinding of products, or the fabrication of anything like that.
Oh, but
You
Jim's
you have to go in
question-
the other way,
Wait a
is what
minute,
I'm
Howard,
saying.
but Jim's question is because if the appraiser currently, if the ag designation for the property, what you're focusing on is the, go ahead.
Yes,
Jim.
but see, that's the thing, is we can run an agricultural business or entity or whatever you
Because
wanna
we have
call it
land
on
that's
a
designated.
property that is designated commercial, that's designated residential, whatever.
Regardless of the appraiser.
Regardless of the appraisal.
Okay, but if he's gonna be building structures according to our code, he needs a site plan.
Not if it's agricultural,
But it,
not if it's an agricultural structure. In that, and we can read it again, and I don't have it in front of
Right,
me.
and this is just.
But it says if it builds a
It
structure,
has BMPs, right? It doesn't-
I don't know, does it say that, where's the
Let me
definition?
just
We've
say
read it a
this.
million times, we just don't have it in front
Can
of
we
us.
take, this was really for
Paragraph.
review and not intense discussion, right, tonight?
But that,
I just brought it up just to say in staff's mind, we have sort of a.
And this is
And
gonna
let
be
me-
coming
as to
up in
what
the
we can
future.
control, what we can't.
And let me say, it's not an easy issue, and as you,
It's
I think
not.
you're having the debate in front of you right now, because you got, I'm not gonna disagree that the vermiculture is not ag, but now, in order to feed his worms, he's bringing in garbage to the site.
But what-
And it turns it's like one use that potentially turns into 4 different applications.
So
Well,
you
then here's the
regulate,
really-
you regulate the
Okay,
garbage.
but-
no, but here's the thing, hold on, because now it's the feed for the critter.
Mhm.
Right.
So why is it garbage?
And it's also.
One person's
nutrition.
junk is another person's antique.
But let me say this, we're at
I'm sorry,
Okay,
it's
hold
like
on,
that.
hold on.
We're gonna drive them right next to your house.
God.
It fits in the neighborhood, right, Beck?
Yeah.
Anyway, it doesn't, just bring it all
That
down
one's
there.
right next to him.
Right,
Okay.
yeah, let me,
You'll
okay,
buy me a beer, we're good.
okay, hold on.
I think we gotta think through this.
Yeah.
A site plan is necessary for any storage.
All right, okay, point of order, hold on, point of order. It goes for you too, Mark. All right, it's 8:10. This was review. I'd like to ask Jim if he has any more to add to this.
No, I just brought it up to
Stir
create
the
some
pot.
discussion.
Right, okay, that's
Yeah, wait,
all right.
that-
It is 8:10. I would like to get to closing comments.
Yeah,
Let's
because
go
we
eat.
got an important
Let's go
basketball
eat.
game tonight.
Let's go eat.
Okay, okay, so we now know what we have for review for the future and how intense it's going to get.
Yes.
And Jim gave us a good example of it. I think that's great. So, anyone, starting with John, closing comments?
Well, it seems to me we've got the agenda already set for the next meeting.
That's exactly what Mark said, July, this is in, what's coming in July.
Plus, there'll be probably a few more things popping up.
But I really do think that, you know, we've got to go through the thought process of, this is a new operation, so residents can challenge it as a nuisance within the first year.
Yes.
And I think it has to be disclosed
Good point.
that they're using garbage. And, you know, I really worry about opening us up to something like that. I think if we can tell them, you know, go out there in the middle of a sugarcane field and do it out there.
That,
I agree with John. I disagree with telling him to go out there to sugarcane field because we don't know how big a chunk of land to find. And I don't know how fast it's gonna take him to go through this stuff, and I don't want to tread on agricultural rights. But it really brings a great conversation. And I looked up the definition, and nowhere in there does it say anything about bean peas, but that's for the next day. I think we did a really good deal today. I think we finally brought up motions that we voted on that we needed to. And I'm actually excited about talking about worms. Can we bring some worms in like a bottle?
Becky.
He wants to sell them at his feed store.
Yeah, I'm getting really excited about it.
I think it went well. I'm glad we made the changes that we made, that I thought we made at the last meeting. I'm glad we clarified it.
Howard?
I'm just looking forward to going home.
Jim?
No, I've got nothing else.
Oh, thank you, Jim, you did enough tonight. Mark?
I did.
No, I think I might have helped, so
Oh, good. I'd like to say thank you, and I want to point out that as Mark pointed out to the town council, every member has shown up to this meeting for every meeting, and that is something that cannot be said of other committees. And that's why, yes, we all go on sometimes, but I think we'll continue to give a little leeway, and we did tighten up tonight so that we're wrapping up early. The next one will be lengthy probably, but we'll try and stay on point and work on our motions and our wording. I think we did a great job. Thank you. Good night. Meeting adjourned.